All right, Ms. Rivers, are you ready? Okay, let's get on the record in State versus Lawson. It is Wednesday, the 5th of February, and I think we're still missing a juror or two. But we've got Mr. Lawson here with his lawyers and our prosecutors are here. So good morning to everyone. Where we left off is that the state had, how are we doing? Okay. Why don't we have Ms. Hansberry call that one just to see where that person is? What number is it? Again? That's the same guy. All right. The state had two more witnesses left. Is that still your forecast?
Yes, Your Honor.
Okay, and they're right outside or nearby?
One's outside, one should be parking now.
Great. We only need one at a time. Excellent. Anything, I got your additional jury charge, so we'll talk about that when we do the charge conference. Seems to fit. I'll figure out where to weave that in. Anything else from the state while we wait on Mr. Dent?
No, Your Honor.
Okay. Good morning, Ms. Rios. Anything from the defense? No. Okay. All right. Then why don't you all be at ease and we'll hope Mr. Dent gets here soon. They turn some light on, that's how you know. Nice. Okay. All right. Ms. Beza, anything else before we bring the jurors in from the state?
No, Your Honor.
Ms. Rios?
No, Your Honor.
All right, let's bring them in. Ms. James is first.
Heather Williams.
Ms. Williams. Okay, Nurse Williams.
Judge, President of the County Court.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, ladies and gentlemen. Welcome back. Mr. Dent, you're 2 for 2. Sorry. That's all right. Don't apologize to your friends here who are here on time. And we do other things connected with the case while we're waiting, but maybe tomorrow, if there is a tomorrow, you'll show up early and have donuts for everyone. We'll see. I'll let you negotiate that with the group. Yeah. All right. We are going to continue with the presentation of the state's case. I told you last night when we broke that Ms. Beza forecast that she had 2 witnesses left. She's sticking with that forecast for now, and I'll ask her to call what may be her penultimate witness.
The state calls Heather Williams.
Oh, yeah, I see. Can you state the spelling name correct?
Heather Williams, Heather. Williams, Williams.
Good morning.
Morning.
Now, we're trying to be about to testify as an expert in strangulation.
Yes.
What information and or documents did you review in this case in order to prepare for your testimony?
There was an arrest record, an incident report, and 911 calls.
Now, where do you currently work?
I work at the Refuge Sexual Assault Center in Vidalia, Georgia.
And what are some of your duties and responsibilities there?
I'm the coordinator of the program, so I make sure that all the patients are well taken care of. The advocates and the nurses that are working for me are well trained and know how to take care of the patients, as well as do some of the sexual assault and forensic non-fatal strangulation exams myself.
How long have you held this position?
I've been there since January of 19.
Where did you work before?
I taught nursing
Where?
at Southeastern Technical College in Vidalia.
And how long did you do that for?
About 10 years.
And then prior to that, did you have any jobs?
Hospice nurse.
And what did you do as a hospice nurse?
I was a case manager, so I was assigned a case of patients to help them through their final days.
Do you have any license?
I do. I have an RN license,
What does RN stand for?
registered nurse.
How about any certifications?
Yes, I'm certified as what's called a SANE-A. That's SANE-A. That's an international certification. It stands for Sexual Assault Nurse Examiner, and the A stands for Adult and Adolescent. So I don't take care of pediatric or child cases. We do adults and adolescents. I also have a certification that's an IVSE-C. That's Interpersonal Violence Strangulation Examination Certified.
And what does that?
It means that I passed the certification test to be able to identify and care for the strangulation patient who is, it was a non-fatal case. So the patients that I take care of are alive.
Now, you're part of any professional organizations?
Yes, I'm a part of the IAFN, which is the International Association of Forensic Nurses, and the AFN, which is the Academy of Forensic Nurses.
Now, you've mentioned in your experience that you have examined patients who have reported to be strangled, correct?
Correct.
In your experience as an RN and working period, approximately how many patients have you personally examined or you supervised the examination?
Personally done a non-fatal strangulation myself that is not tied to a sexual assault. It's high 80s, 88, 89. However, some of the sexual assaults that I have performed, the exams that I performed also have a strangulation component in it, and that would be high 30s.
Now, what is a strangulation exam?
A strangulation exam when you come into my center is a very specific head to toe. First, we start with a discussion with the patient. We get their medical background, their medical history, and then we start to discuss with them what happened. We let them tell us what happened during the case or during the assault to let us know how that guides our physical exam once we get into the exam room. What are some specific areas that we need to pay attention to that could have been injured? Whether we actually see anything or not. So we take them into the exam room after the discussion and we do a head to toe, basic head to toe, everything from the top of their head to the bottom of their toes that we either see an injury, the patient complains of pain, or they state something happened to that area of the body we hyper focus on. We take a series of at least 3 photos of every identified injury area. So that we can make sure that we get a good look at it. And then possibly using other things such as alternate light sources to help us identify other injuries that we can't quite see with our naked eye.
Have you taken any strangulation focused trainings?
Yes, I have.
Please explain to the jury what type.
There is an organization that falls under something called the Alliance for Hope International. It is called the Training Institute on Strangulation Prevention, and that's out of California. I've attended their 4-day advanced course training on strangulation. Once you complete that, you are eligible to attend their 2-day Master's Summit. I have completed that, as well as attended in Texas their 2-day Expert Witness course. And then they offer webinars and trainings virtual all the time that I'm always attending.
And you mentioned previously, but can you please further explain to the jury, have you done any presentations on strangulation?
Yes, I have presented on this topic at the local level to our local law enforcement, GBI, our medical professionals in the local area that I serve, as well as through GIPSTIC for regional, which is the Georgia Public Safety Training Center in Forsyth. I've also trained at the national level at conferences such as the EVAWI, which is End Violence Against Women International, on this topic, as well as a Georgia-based annual conference, which is the Georgia Coalition Against Domestic Violence.
Have you previously testified as an expert in strangulation?
Yes, I have.
Do you know approximately how many times?
4 times.
And at this time, the state would move to deem Ms. Heather Williams an expert in strangulation.
Ms. Feely, would you like to voir dire or examine Ms. Williams on this topic? Okay. And ladies and gentlemen, so you know, Ms. Beza is not done. She's going to have more questions, I suspect, for Ms. Williams. But when we get to this question of do I qualify Ms. Williams as an expert, the other side is entitled to ask questions about qualifications as well, so that I've heard not just the questions the state might want to ask, but that the other side might want to ask about Ms. Williams' qualifications. So I'll hear from Ms. Feely, rule on the request to qualify, and then Ms. Beza will be back up.
So I have your resume here. I see that you have a bachelor's in nursing, is that right?
Correct.
And you have a graduate certificate in nursing education.
I have my master's of science in nursing, and the focus of that was in education.
So you do not have a PhD, is that right?
I am not.
And you do not have an MD as well?
No.
We don't have any background about what organizations you got your certifications from, right?
I haven't provided any information about my certifications and how I obtained them.
And you just testified that you have testified in a trial 4 times. I have what must be an older copy of your resume. I have that you once testified in Fulton County as an expert witness, is that right?
Correct.
And you once testified, not in a trial, but in a sentencing hearing.
Correct.
Then I have that you consulted on a strangulation case. Can you tell me what was other times you testified?
They were in my local area. One was in Emmanuel County and one was in Toombs County.
It was at trials?
Yes.
That's all I have to give you questions on.
Okay. Do you have, other than having fleshed out this situation, do you have any objection to having Ms. Williams qualify for purposes of this trial as an expert in strangulation?
Because based on the demonstratives that we received from the state, it does appear that she will be testifying about anatomical, medical situations that it's our position she's not qualified to testify about.
Okay. I'm going to qualify Ms. Williams as an expert in the field of strangulation, and the concerns that you all in the jury have heard from Ms. Feely would go to the weight of the testimony as opposed to its admissibility. So for the purposes of this trial, you are an expert in the field of strangulation. Ms. Beza.
Ms. Williams, can you please define choking and strangulation in any difference?
Sure. So a common misconception is that when anybody who is, they say they're choked out, and they use that word when they're trying to explain some type of assault where something was put on their neck. The true meaning of the word choke or choking is when you take a bite of something that's too big, you try to swallow it, you can't, it gets stuck. Choking is an internal, inside the body cause. It's an airway cause inside the body. That is choking. Strangulation is an external, outside of the body cause. And strangulation, it can impede not only the patient's ability to breathe, like choking, because pressure is being applied on the outside of the body, but it also concerns us that there may be cardiovascular issues with blood getting to and from the brain.
Can you please describe what different methods there are of strangulation?
So there are 3 different manners of strangulation. The first one is manual. A lot of times when we say manual, we think hands. Manual means any part of the body. So it could be hands. It could also be the crook of the arm. Someone comes up behind and puts someone in a rear chokehold. That could be considered strangulation. Any other part of the body, the forearm, the knee, the lower leg, any part of the body that's putting pressure against the neck, that is manual. Ligatures are anything else. It could be a wire, it could be a telephone cord, it could be an article of clothing or a scarf. And then we have hanging. Hanging is strangulation that occurs based on the weight of that patient's body strangling them. So there has been something placed around the neck, and then they are hanging where their feet are no longer touching the ground, and the weight of their body causes the compression around the neck, causing the strangulation.
Now I'm going to ask you to define asphyxia and hysphyxia, but we're looking at a demonstrative help aid in that explanation.
Sure.
I'm looking in front of you at State Exhibit 55.
Mhm.
Would this demonstrative help aid your testimony in explaining asphyxia and hypoxia?
Hypoxia. Yes.
Cannot pronounce these words.
Sure, we can use this.
Your Honor, at this time, the state moves State's Exhibit 55 into evidence as a demonstrative exhibit.
Ms. Feely, any objection to States 55 as a demonstrative? It's admitted.
Publishing States 55 at this time. Can you please explain asphyxia and hypoxia?
Hypoxia is simply the condition of having low oxygen in your blood. And it could be from a number of different reasons. Asphyxia is the body's inability to either bring in oxygen into the body or the body's inability to deliver oxygen that has gotten into the body to the different body tissues. So specifically in strangulation, we're referring to the body's inability to get that oxygen-rich blood to the brain. So asphyxia, we can't either bring it in because maybe our lungs can't expand. There's pressure on our lungs and we can't take that nice deep breath to bring that oxygen in. Perhaps there's pressure on the throat that they cannot, and the airway is smaller, more narrow. They feel like they're sometimes breathing through a straw and they can't bring in enough air to get enough oxygen. Or if they're breathing and they're doing fine with bringing it in, it's not getting to where it needs to because there's some type of blockage, not getting it to the tissues it needs.
Now, using State's Exhibit 55, in your expert opinion, if someone was being strangled with a forearm directly to the center of their neck, so person is on top of putting pressure on the center of the victim's neck with their forearm, kind of how would that affect this exhibit, this neck?
So if you see in the middle where it says trachea and larynx, that is the dead center of your throat. That's your airway. And if there is pressure being put directly on your airway, that is going to lessen the amount of oxygen that you can bring into your lungs when you try to take a good deep breath. So that can cause asphyxia because we cannot bring enough oxygen into the body. If there's anything that is compressed on the side of the neck, that's where we see the red lines. Those are our carotid arteries. Those bring oxygen-rich blood to the brain. And if at any time the sides of the neck are compressed, those can be impacted. But specifically talking and concern for the front is that we're making that airway smaller due to the amount of pressure that's being applied.
And in your expert opinion, if there's pressure applied to the trachea or that front part of the neck, would that person, obviously it depends on the amount of pressure, et cetera, but could that person feel like they were about to pass out?
Yes.
Now, let's talk about or move towards the external signs of strangulation. First, I would ask you, where would you find, if there were, visible signs of strangulation?
That's a very broad question. We look, of course, anywhere on the neck, front, sides, back. We look under the jaw. We look down in the collarbone area. We look behind the ears. We're not always privy to having marks anywhere, but we do examine the entire neck, under the jaw, behind the ears.
And for the juror's knowledge, what is petechiae?
Petechiae, petechiae are little tiny red pinpoint dots that appear on the skin, and they occur when there's a buildup of pressure in the vascular system. So in the body, in our neck area, big fat carotid arteries that carry that good oxygen blood to the brain. It drops it off, brain stays alive, but that blood needs more oxygen, so it drains back out through the jugular veins, again, which you have on both sides of your neck. If the jugular veins, which sit a little bit closer to the skin, if they are blocked, but the carotid arteries stay open, then blood is going up to the brain, but it can't get out. It's kind of like a kink in a water hose. And behind that kink, the water's still coming and the pressure's building. So behind that kink, the blood is still coming, but the pressure is building. Well, there's not infinite amount of space in the brain that it can go. So when it gets to the tiniest little parts called capillaries and that pressure's too much, they pop, they rupture. And then they show themselves on the skin, perhaps on the roof of the mouth. We can see them in the ear. You can see them literally the whole body. They can show up anywhere. that's what we see is that buildup of pressure, and those petechiae are the evidence that we see from the blood vessels popping from the buildup.
Now, in the manner of strangulation that I described before, kind of forearm being pressed against the middle of the neck, in your expert opinion, could that cause the person being strangled to have pain to her neck in the following days?
Yes, absolutely.
How about dry mouth or coughing?
Yes.
Why is that?
Those are common symptoms, actually. Anytime the neck is very delicate. The muscles in the neck are very delicate. And oftentimes when a patient has been strangled, it's almost, if you've ever been in a car accident, that day you're like, I'm fine, I'm good. And then you wake up the next morning and you're like, wow, I'm hurting all over. None of this happened yesterday. It's the same concept because you have this trauma response, your adrenaline is rushing, you're in a life-saving, life or death moment, and you don't realize what hurts actually at the very moment. Sometimes it takes a little bit of time later, and then you start noticing things like, it hurts to swallow today. It's a little difficult to swallow like solid food. Or gosh, when I turn my neck certain ways, it's kind of sore. Or I'm having trouble sleeping. I can't get comfortable on my neck to sleep. And those are all very common symptoms after any type of strangulation.
And do you sometimes find in your expert opinion that there is no outward injury that you can see with the naked eye after a person is strangled?
Absolutely.
Please explain to the jury about why and about that.
If I don't see anything, I am not upset. I'm not overly concerned. If I do see markings, I'm not upset or overly concerned. The presence or lack thereof of marks on the outside of the neck does not mean anything, does not speak anything to the severity of the strangulation or if a strangulation occurred at all. We have studies that show us 50% of the time after a strangulation, there will be no marks on the neck. Of the remaining 50%, 35% of the time, there might be marks that are slight, but maybe visible to the naked eye, but they don't photograph or video well. Because, you know, what we see with the naked eye is better than what we can photograph most of the time. So the 35%, they might be there really faint, don't really show up. That leaves 15% of the time that a patient is actually strangled. Are you going to have ligature marks, pattern marks, scratch marks, anything, bruising, petechiae that you can equate to the strangulation? So if they show up for their exam and they're seeing me and I don't notice any marks, that doesn't tell me that nothing happened.
No further questions for this witness. Thank you.
Ms. Feely, do you have questions for Ms. Williams?
I want to start with, you said something very interesting that I wanted to follow up with you about. You said unequivocally that the lack of any physical evidence speaks nothing to the severity of the strangulation. Is that your testimony?
Yes, it is.
Now, if it is a fatal strangulation,
Yes.
the medical examiner will be able to tell that. Is that right?
If it is a fatal strangulation, we have studies that showed up to 40% of strangulation homicides have 0 external marks at the time of autopsy.
When they have the autopsy.
When they cut them open, yes.
Well, let Ms. Feely finish her question and then you're free to answer it.
So tell the jury about what would be seen internally.
On autopsy, I'm not a pathologist.
Oh, okay, so you're not an expert in that, okay? So you also said that 50% of people claiming to have been strangled don't have any outward.
That is correct.
So if I had been strangled an hour and a half ago, this is what I would look like, most likely.
It's very possible.
And what about if I had been strangled yesterday? This would be what I would look like?
It's very possible. Everyone bruises differently.
Sure. So if someone was strangled and the next day or 2 days later, there could come bruising at that point from the healing process, right?
It's possible.
Now, you also mentioned that when you do exams, you take at least 3 photographs of each injured area, right?
Correct.
And you make sure that you use optimal light settings.
Correct.
And so just to be clear, that anatomical drawing that you were using, and you were telling the jury all about that, you can't tell me anything about what internal findings would be from somebody who died of strangulation.
Objection, Your Honor. This witness is not a pathologist. She doesn't do autopsies. She's an expert in strangulation, not pathology.
Okay, that may be the point that Ms. Feely is making. So would you repeat your question, and then Ms. Williams, you should answer it.
As an expert in strangulation, you are telling the jury that you are not familiar with what the findings would be from somebody who died of strangulation.
I am trained on the anatomy and pathophysiology of strangulation in non-fatal cases.
So that's it.
I do not do autopsies.
And in all of these trainings that you've done in strangulation, you've never had any training about what findings there would be in fatal strangulation.
My training is on the non-fatal strangulation patient.
Now, in this case, you did not look at any medical records, is that right?
I did not have medical records.
Didn't look at any imaging or anything like that?
I did not have imaging.
You did not examine any photographs of the alleged strangulation victim?
I did not.
You didn't speak with the responding officer?
I did not.
You didn't speak with Ms. McCrary?
I did not.
You didn't review the police report?
I did review it, and I believe it was titled an incident report and a arrest report.
So you reviewed a record of what someone else told a police officer, is that right?
Statements were in those reports.
But those statements were not made to you?
No.
Now, you mentioned your local area is Vidalia, so you came to Atlanta for this trial, is that right?
Yes.
You're being paid by the Fulton County District Attorney's Office, right?
I'm currently not being paid by the district attorney's office.
So you voluntarily just came up here for trial?
This was considered part of my job for today.
And in your 4 times testifying as an expert witness, those were all for district attorney's offices, right?
Yes,
You have never once testified for a defense attorney?
I've not been asked.
And what is your full-time position again?
I'm the coordinator at the Sexual Assault Center.
And you have never examined someone and determined that they were not strangled, right?
That's not up to me to decide.
So no.
It is not up to me to decide whether or not the strangulation occurred.
So I guess my question is, in all of the people you've examined, it's your testimony that they were all victims of strangulation?
I believe my patients.
Ms. Beza, any redirect?
Yes, Your Honor. In talking about, we're cross-examined on external injuries and internal injuries. To clarify with strangulation, what are some different factors that may determine whether or not a person would have external injuries after a strangulation?
The amount of time that the pressure was held on the neck, the amount of pressure that was held on the neck, the item. So was it something small or something large? something like a wire versus hands. That can make a difference as to whether or not you see anything. The patient's underlying health conditions, there are certain health conditions that make people more prone to bleed. Are they on blood thinners that may make them bleed easier? Certain cancers can make you bleed easier. There are a lot of different factors go into whether or not you're going to see something.
The skin color factor as well, whether.
The darker the skin, the more difficult it is to identify bruises.
No further questions.
Ms. Feely, any recross?
No.
All right. Jurors, any questions for Ms. Williams? Thank you. Ms. Williams, from your experience and training, can hypoxia, that feeling of lack of oxygen, or maybe the actual lack of oxygen, occur just from someone sitting on a person's stomach or chest area? Because you did a lot of talking about throat, which is what we think of when we think of strangulation. But if that force or pressure is applied by the weight of someone's body or body part on the chest or the stomach, can that also cause that feeling of lack of oxygen? Is that the
Yes.
clear question?
Yeah, very clear. Can I
Okay.
address it?
Please.
So if someone or pressure is being put on either the chest or the abdominal area, if it's the chest area, then it's going to impact our lungs' ability to expand. So we can't really deep to get good oxygen in. If it's the abdominal area, then we have to worry about, is the diaphragm being impacted? Because in order for the lungs to expand, the diaphragm has to be able to move up and down. If the diaphragm is not able to move down to make room for the lungs to expand, then you're not going to be able to get good air in. So yes, to answer the question, any pressure on the chest area or the abdominal area can impact that person's ability to inhale quality air to be able to oxygenate the body.
Ms. Beza, do you have any follow-up based on that?
No, Your Honor.
Ms. Feely?
So to be clear, sitting on someone's chest or stomach is not strangulation, right? It can affect their breathing, but it is not strangulation.
It's positional asphyxia is what it's called.
Thank you.
What is provisional asphyxia?
Positional.
Oh, positional. I got
Positional.
that. Okay, it's a provisional. All right. Thank you so much for your time. Appreciate it.
Yes, sir.
Ms. Beza?
State calls Rosa James.
Face me, raise your right hand. You swear affirm that testimony you'll give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You ain't gonna see it. Can you state your name, right?
Rosa James, RosaJames.
Good morning.
Good morning.
Where are you currently employed?
I am currently employed with my own contract company, Zinnia's Place.
Can you please tell the jury what Zinnia's Place is? Zinnia's Place is.
Can you
Zinnia-
spell it?
Yes. SANIYAH.
Thank
Place. Zinnia's Place is my contract company. I use that company to do speaking engagements, training, research behind intimate partner violence and gender-based violence, and also expert testimony.
And how long have you had that?
I started the company in March of 2023.
Where did you work before?
Fulton County District Attorney's Office.
As what?
I was the domestic violence trainer. I was the senior advocate for victim witness, and I also did expert testimony.
And how long were you at the Fulton County District Attorney's Office?
I started at the Fulton County District Attorney's Office in July of 2019.
Now, Ms. James, do we know each other through your work at the Fulton County DA's office?
Yes,
And have we worked on other cases together?
yes.
However, in relation to this case, do you know anything about this case?
No, I have no idea.
Why were you hired as an expert to testify in this case?
I was hired to do the science behind domestic violence and inform the jury about what domestic violence is on a deeper level than just what the community members know at this point.
So as a general expert.
Yes.
Now, can you please tell the jury your work with the Georgia Coalition of Domestic Violence?
So when I worked at the Georgia Coalition Against Domestic Violence, I was a training coordinator. So what I did with them is that I trained advocates on how to service survivors of domestic violence throughout the state of Georgia. That was a real focus, and also creating content and training material for advocates throughout the state of Georgia.
And did you ever work for the Florida Coalition of Domestic Violence?
Yes, during that time at the Florida Coalition Against Domestic Violence, I was still doing the same thing, but I had additional duties with the CDC. And I also had to monitor multiple domestic violence sites, grants, Violence Against Women Act, and all such, and reporting to the CDC and also reporting to the Office of Violence Against Women.
How long did you work for the Florida Coalition?
About 2 years.
And how about the Georgia Coalition?
I worked there about 9 to 11 months, grant funding. It ran out, so.
Now, did you have direct contact with victims of domestic violence through any of your prior employment?
Yes, I started in the domestic violence movement in 2012. I was a community advocate community and prevention advocate with Harbor House of Central Florida. That is in Orlando, Florida. And I was with them for about 5 years. And that's when I made the most of my direct contact with victims.
You know approximately how many victims of domestic violence you've worked with?
Well, between hotline calls, face-to-face, email, training, well over 20,000.
Now, do you regularly attend trainings on domestic violence?
Yes, in order for us to stay certified, we have to be up to date on what is current. And every year I have to get like a 6-hour training from the right now the Georgia Coalition Against Domestic Violence, and the Prosecution Association does those trainings to keep those certifications.
What is the Fatality Review Board?
The Fatality Review Board basically is a board where we do a deep dive into domestic violence homicide deaths, and we see what services they may have touched or what may have not, and we try to figure out what was a better route for that personal survivor. And I've also worked with murder-suicide type cases where we figured out that the bulk of those cases are intimate violence related.
You conducted studies on domestic violence?
Yes, outside of my current PhD candidacy, I also did primary prevention with the CDC, where we looked at a public health model to prevent intimate partner violence from ever happening to someone. And that was a very in-depth type research study. And we work with universities, we work with community members, and I oversaw 42 centers in Florida throughout that program.
Have you testified in Georgia court as an expert in domestic violence?
Yes.
Have you testified in Florida court as an expert in domestic violence?
Yes, 27 times.
How about Georgia, if you know?
I'm on 55, 56? We got what's 27 minus 60? 50, I'm a social scientist, I know. Yeah, so something like that.
That was a funny experiment. We got like 9 different numbers out of the jury.
Yes.
Mr. Dent, our engineer, didn't even offer one.
Now, what is generally, after we ask the junior and expert, what is generally power and control and cycle of abuse?
So the definition that we go by for domestic violence or intimate partner violence is a pattern of coercive behaviors that is used to gain and maintain control over the survivor in the relationship. So there is a power dynamic that the batterer or perpetrator has, or one partner has in that relationship. And it is done to maintain control over the survivor and keep that survivor in that relationship and that power dynamic.
What's the cycle of abuse?
The cycle of abuse is, we basically use that for victims to show how they stay in these relationships long term. And it's a full cycle from engagement all the way to, people call it the honeymoon phase, but we are changing that. That's basically reconciliation.
Now, Your Honor, at this time, the state would ask Ms. Rhoda James to be deemed an expert in domestic violence, power control, and cycle of abuse.
Ms. Feely, Ms. Rios.
Yes, that's my question.
Okay, same process as before, ladies and gentlemen. I bet Ms. Beza will be back. We're focused right now on this question of qualifications.
Good morning, Ms. James.
Good morning.
Have not obtained your doctorate degree, correct?
No, I'm an actual candidate at this point.
You have written a dissertation on domestic violence, cycle of violence, or power control, correct?
That is my current dissertation. Those are in my current writings right now.
You have not spoken at any conferences regarding cycle of violence and power control?
Conferences,
Yes.
I have.
The only professional license you currently hold is a Florida registered clinical social worker.
Yes.
And that means that you're only able to provide social work services under the supervision of a licensed social worker.
No. What that certification is a mental health clinician, and I would have to be supervised to do diagnoses and such, but I do not do that. And I don't do mental health services.
Okay. Ms. Rios, do you have any objection to having Ms. James qualified as an expert in domestic violence, the cycle of violence, and power and control?
I do, Your Honor. She has not obtained her PhD. She has not or completed her dissertation, so I'm asking for her not to be deemed an expert.
Okay. As with the previous expert, I think you'll be able to argue those things in terms of the weight the jury ought to give Ms. James's testimony, but I don't find a pending PhD to be disqualifying, and I will qualify Ms. James as an expert in the field of domestic violence, power and control, and cycle of violence. I think those were the three. They're all intermixed. I think the jury knows what we're talking about.
Ms. James, can you please define domestic violence?
Domestic violence or intimate partner violence are used interchangeable, is a pattern of coercive behaviors that one partner in the relationship uses to gain and maintain control over their other partner.
Widespread is domestic violence.
At this time, is 1 in 3 women will experience domestic violence. And I believe we're at 1 in 4 men now. It used to be 1 in 9 about a year or two ago, but reporting has been climbing. So 1 in 4 males will experience domestic violence in their lifetime.
What are some common misconceptions about domestic violence?
The biggest common misconception is that the abuse will end if the person just leaves the relationship, which is not true, because when you leave the relationship, it's a loss of power. So that's the most vulnerable and lethal time in the relationship, when someone is trying to exit. And also when a firearm is introduced, that goes up 500 times of being a homicide victim. So it is not the safest time of the relationship.
Based on your training and experience, what do most people believe about an individual who remains in an abusive relationship?
They believe that they want the abuse, or somehow want to be abused, or they enjoy that type of dynamic. But if we go back to the definition, there's a power and control dynamic. It may be fear, children, economic. there's reasons why someone would stay in those type of relationship, and it's not just, I want to be in this relationship.
Now, you previously testified to the cycle of abuse. And I would like you, would a demonstrative help you aid in your testimony as to further explaining the cycle of abuse to the jury?
Yes.
You said cycle of abuse. Is that the same as cycle of violence?
Yes.
They're interchangeable?
Yes.
Okay.
I want you to look at State's Exhibit 57. It's on your,
Oh,
would that demonstrative help aid your testimony today?
yes.
Okay. Your Honor, at this time, the state would like to enter into evidence State's Exhibit 57 as a demonstrative.
Ms. Rios, any objection to States 57 as a demonstrative? It's admitted as such.
Publishing at this time. Can you please explain the cycle of abuse, cycle of violence to the jury?
Yes, this cycle is what we use for survivors to show how the survivor is caught up in the relationship, right? So the first part is the tension building phase. Survivors know when their partner is about to have an episode. So, and during this tension building, there is a breakdown of communication, there's fearful, they're walking on eggshells, or to the public, it may seem that the survivor is subservient and that he or she is trying to maintain intimacy in the relationship, but really is that I know this incident is going to happen. And then we go to the incident. A lot of people feel as if the incident is only physical, but it's not. The incident can be verbal abuse. It can be humiliation in front of family and friends, blaming, intimidating, arguing, or it could just be a physical altercation and one of the partners is arrested. So reconciliation, this can be multiple ways, right? What we think about is the abuser apologizing, taking ownership, or like giving the survivor or partner gifts, but that's not what that is. This reconciliation, a lot of times the perpetrator will deny that the abuse ever happened, make the survivor feel as it's their fault. This is where we come into contact with survivors. You know, if the partner is arrested, we see survivors recanting. This is to say the spot where we see where survivors are putting money on what we call books at the jail. This is the part where it gets kind of mucky, where people think that, oh no, they love this person. No, they're trying to, the survivor is being manipulated at that point and they feel like it's their fault. So they're trying to resolve it. And then calm, like I said, we're trying to phase out honeymoon phase, because when you think about honeymoon, you feel like, oh yeah, it's a great time. No, it's just really the incident is forgot about. It never happened. We're moving on with our relationship. It's calm and nothing is happening. This person is back to who they were when I first met them. So we're just going to move on. And then we go back to the tension building because this is ongoing. Like I said, it's a pattern. So this is ongoing. Different tactics, different ways to keep this going and to make the survivor feel as if they're the blame or they have some type of mental illness or that they are in some type of psychosis, but it keeps going.
Now, are you familiar with the power and control wheel?
Yes, the power and control wheel is an evidence-based tool that we use with survivors to have them understand what intimate partner violence is and what their perpetrator or batterer or partner did to keep them in the relationship as fearful or them feel as if they have to stay, or it could be a survival skill in the basic needs in it.
And we're looking at a demonstrative of the power and control wheel help aid in your testimony and explaining it to the jury.
Yes.
And in your State's Exhibit 56, will this demonstrative help aid in your testimony?
Yes.
And at this time, the state moves into evidence State's Exhibit 56 as a demonstrative aid.
Ms. Rios, any objection to States 56 as a demonstrative aid? It is admitted as that.
Publishing it to the jury.
So although this evidence-based tool was created in the 1980s, this is an updated one. We continuously update this wheel to keep up with the times at hand. If you look at this wheel, you'll see that it's gender neutral. And also you'll see other factors on the outside that you may see that will keep someone in that relationship, or tactics that the abuser will use. And on the outside of the wheel, we see physical and sexual violence. Those are, you can be arrested for those things. Those are what the public sees. You know, we may see poverty, sexism, and all these other things on the outside. But what I like about the wheel is on the spokes, it shows things that you may not see, right? Using intimidation. And intimidation can be used in any type of way, just sitting a bullet on a counter. Emotional abuse it's just not calling this person out of their name. Is also humiliation, degrading acts in front of family and friends, or make them feel as if they're less than. Isolation is a slow process. That means the abuser will have the survivor cut off from all support system, and basically want the survivor only to contact or be around them or people that support the abuser. And the minimizing, denying, and blaming is joking about it. It's like, that wasn't that serious. You're taking this too seriously. We were just wrestling. We were just playing, when in reality, it was a incident. Children is a major part of this, because using children is a very manipulative way to keep the survivor in a relationship. Any partner in a relationship, children are vulnerable, and you want to keep your children safe. So there are many survivors who will stay in a relationship because they feel as if the children are here. If I'm here and the children are here, then the children are safe, right? But then there may be a separation, and the abuser will use the children as a way to identify and stalk the survivor. It could be exchanging messages, threatening to hurt the children. It's a lot of manipulation in this. Privilege can be anything now. That's why it's gender neutral. It's not just male privilege. It's privilege of basic needs, everything. Like, if this survivor was trans and transitioning, it is hard for medical services. And also the exposure of that may prevent a survivor from coming forward. It's a combination of faith, race, and culture that can keep that survivor trapped in that relationship and embarrassment from society. Economic abuse is more than just putting money in a bank account and the survivor having no access. I've seen survivors be economically abused where the batterer or the abuser will cut cords in their car so their car won't start, so they can't go to work. I've seen people calling their partner's job like 10, 15 times a day to get them terminated. I've seen survivors' credit be ruined. They'll put their name on different things, such as cars. They'll put it on an apartment, and then now we have an eviction and all these other things. Allowance. I've had survivors be given an allowance of $20, up to $20 a week. And this is all the money you're going to get. So basically, using economic abuse is taking any type of monetary, taking any type of way to create an environment where the survivor cannot thrive financially. And coercion and threats, coercion and threats is more than just threatening the survivor. We're threatening children, family members. Like I told you, we did the study on the fatality review of murder-suicides. The abusive partner is threatening to complete suicide, and usually they will take their partner and their children with them when they do that act, and that's a real act, and it happens in many, many cases. Using the authorities, having law enforcement come to the home and threatening to tell them that you use the survivor used substances. And that's a whole nother area that we're researching now, how using substances is used against the survivor, although the perpetrator or the abuser started the addiction, right? So all of these things inside this spoke and on the outside equals power and control. But we'd like to highlight this wheel because there are a lot of things that the public don't see, or is a deeper understanding than just physical incidents.
Now, you mentioned a lot of different things, a lot of different examples.
Yes.
Of how an abuser exerts his power and control over a survivor. First, why do you use the word survivor?
So survivor, well, in our movement, we use survivor or thriver. There are victims who don't want to be labeled as victim, and in society you get to label yourself how you want. And some survivors decide to be survivors, they try to be thrivers, but in domestic violence homicides, we call them victims because they are now a victim and they succumb to their injuries.
In your expert opinion, you just went through a lot of different ways that abusers can exert their power and control over victims. In your expert opinion, are there a certain number of events that have to happen for a person to be a survivor?
No, it just has to be a coercive pattern. It just has to be a pattern, right? I know there are isolated incidents, but isolated incidents between couples and intimate partner violence is completely different. There is a pattern. We have reports of past history and family members coming in and saying this dynamic exists.
In your expert opinion, can abusers try to control their victims by using their property? For example, their cars without their permission?
Yes, that can be a part of economic abuse as well. I have to be to work at 9 o'clock and you take my car at 8:50 and I can't go to work, right? That's an economic abuse. Or I can't get the children to their doctor's appointments. I can't get them to school. It is a multitude of things where you can use property, you can use the apartment, locking the survivor out at random times and not coming home. Yes, property can be used as a tool or a tactic for power and control.
Now, in your expert opinion, is it unusual for a victim of domestic violence to remain in a relationship with his or her abuser after the abuser physically assaults them? For example, like pinning them on a bed.
Yes, that's the cycle of abuse, right? We just went through that where the victim or the survivor may feel as if this is their fault, that I deserve this. And ultimately, we can't forget about love. I mean, when you're in love, you think that these things are normal and that any type of lay relationship outside of abuse would may excuse their partner's behavior.
Now, in your expert opinion, is it unusual for a victim of domestic violence to remain in a relationship with her abuser after the abuser verbally assaults them by calling them out of their name, like bitch repeatedly, or even calling them their ex-wife's name?
Yes, that is very common, actually, calling the ex-wife or the wife has died, their names and things of that nature. It uses as a self-worth tool that you deserve this and that you are not as worthy as I am in this relationship. So yes, all of that can be used to create an environment where the survivor feels that they deserve these things or they need to stay.
Now, in your expert opinion, do victims of domestic violence stay? And we talked about this a little bit because they rely on their abuser financially for money to help with rent or help with bills.
Yes, that's economic, right? Basic needs. That a lot of the number one cause of homelessness for women and children is domestic violence, leaving a domestic violence relationship. So of course, I'm going to stay in this relationship if I have housing, if I have food, my children are protected as far as I'm thinking they're protected. I'm going to stay and we're going to split the bills and things of that nature, but it is economic.
Now, at what point in your expert opinion do you see victims fighting back by either shooting their abusers or physically fighting back?
The biggest thing when they fight back, when survivors fight back, is fear of their own lives, right? Stand your ground. We have all types of laws around that. If you are in general fear of your life, you're going to fight back. Or if the children are being assaulted, you're going to fight back. Right? That anyone would do that, even in intimate partner relationships.
And in your expert opinion, say the children were in the home, would you find it an oddity if the survivor fought back by, say, shooting their abuser?
No, it's not odd. That you're protecting yourself, you're protecting your children, you're protecting your life. And if it's a threat in your home, you're going to use any type of weapon, firearm, or whatever you need to do to disable the threat.
I have no further questions for this witness.
Ms. Rios, do you have questions for Ms. James?
Yes,
Your resume doesn't mention any specific speaking engagements in the realm of domestic violence, sexual violence, and power and control. Any specifics?
Yes, it does. It should be an updated CV It has a whole list of conferences, a whole list of engagements and speaking engagements, and also it should have memberships and things of that nature.
Resume stated that you have testified in other trial hearings, correct?
Yes.
You only testified for the state in those cases, correct?
No, I testify for the defense as well.
How many times have you testified for the state?
In Fulton County once.
You've only testified for the state in Fulton County.
Oh, you said for the state?
Yes.
Ooh. I will say for the defense, I've testified once for the defense, but in Fulton County, and I will say I had consultations with the defender's office in Augusta, Georgia, and also Oregon.
For the state, you go ballpark,
The bulk of them, maybe
so. Said, 20,000, or that
was survivors.
100 for the state.
No, that was discussed during qualifications. I've been brought in over 50 times, so I don't have an approximate number for you, but I do have experience with the defense.
So 50 for the state, 1 with the defense.
I wouldn't say that. I would say consultations, as far as testifying once, but consultations multiple times. Once.
You were an employee with the Fulton County District Attorney's Office for 4 years, correct?
Yes.
Is that full time?
Yes.
You describe yourself as a senior victim witness advocate, advocate and domestic violence trainer expert.
This is when I was with the Fulton County District Attorney's Office.
So right now you're doing a separate contracting.
Yes.
And when you were working at the district attorney's office, how many victims did you work with?
Ooh, so understand with senior, when you're doing a victim advocate, it is a multitude of victims, especially with homicide. It's not just one. So maybe 500, because I'm dealing with family members, and I remember a case with 27. So I can't give you a ballpark, but it's multiple than just that one victim.
Mostly women.
Yes.
Men report domestic violence less.
Yes.
The current statistic that you mentioned was 1 in 4 men have experienced domestic violence,
In their lifetime, yes.
but that number hasn't been increasing.
Yes.
And you also stated on the direct the most lethal time for a domestic violence victim, the most lethal time for them is when they're trying to leave the domestic violence situation.
Yes.
And when a gun's involved, the chances of it being a fatal situation goes up 500 times, you said?
Yes.
And that can go for male and female.
Yes. That's why we use gender neutral terms.
You have not published any research on power and control and cycle of violence.
Not directly, but I have published research on intimate partner violence.
You have not engaged in any scientific training on domestic violence, cycle of violence, and power control.
I have, and I also have conducted those trainings.
You do not have an objective set of standards and guidelines that you follow for each case, correct?
Each case is a separate entity.
You haven't talked with any of the witnesses in this case, correct?
No.
You have no idea about Ms. McCreary's social background.
No.
You haven't spoken to the responding officer.
No.
Haven't reviewed any police report for this case?
No,
Haven't looked at any academic studies for this case?
no, I haven't academic studies. Okay, no, I have not.
You didn't review any medical records, from Ms. McCrary in this case?
No,
Did you look at any medical records for the defendant, Larry Lawson?
no.
Can I see that demonstrative?
Which one? Power control or cycle of abuse?
The purple one, was that power control? That was this. I have it, but
Let me pull it.
or maybe it was, I think it was a,
Power and control is
Power
your,
and control, yes.
yeah, the wheel.
Let me
you
pull it.
have one in front of you, I have one here. So I know you said that it had been updated since the 1980s.
Yes.
And so with the update, just removing the male from viewing privilege.
No, actually, we have multiple wills. We have a will for healthy relationships. We have a will for intimate partner violence between the LGBTQ community and different types of sub wills for that happens in different populations. I just use this one as a universal.
The viewing privilege states, treating you like a servant, being the one to find generals. That's typically connects to male privilege.
No, not at this current time.
I don't see anything on this power and control will that accounts for mental illness, substance abuse, or reciprocal domestic violence. Is that
I see substance abuse on the outside. So substance abuse is a thing. Mental health is culture, language, homophobia. These things are on this wheel that we discuss.
it's just not one section for those things?
The section is on the outside because those are things we see.
Would you agree that someone suffering from any type of physical or mental disability is more likely to be a victim of domestic violence?
Yes.
Both the power, control, and cycle of violence are based on subjective and not objective observations, correct?
No, these are research-based evidence. These are evidence-based. These have been had qualitative research in science.
If it's possible that observations noted by one domestic violence expert would not be observed by another.
As far as these two tools,
Yes, or in your own cases.
this is a science. There's no, can you repeat that question? I'm trying to understand what you're trying to ask me.
As possible to notice, observation noted by Ms. Walker, who created the will, would not be observed by a different person in the same field.
As far as the qualitative data in the science, they will. This isn't just an observation or something that was thrown together. This took years to create these two tools.
How have you decided the relationship is one of power, control, or an isolated incident?
So we're looking at the definition that it's a pattern and it's coercive and there's a power dynamic between the partners.
by talking to the people and their experiences.
Yes.
In a particular relationship, if power and control is not an issue, it wouldn't be relevant, right?
Relevant to,
The power and control cycle, if there's no, one person has more power than the other in that particular relationship, it would not be relevant.
so when we think about the definition, we're talking about domestic violence and intimate partner violence in in a coercive pattern. Isolated events happen, but that most likely would be in major cases. I would not be sitting here, but I'm just here to explain the science behind intimate partner violence and what we speak about in the movement.
If you're talking to a survivor, you're trained to believe that person.
Yes.
Does anxiety play a role in these incidents?
Society, how?
No, I'm sorry, anxiety.
Anxiety. That is a mental health diagnosis, and I cannot diagnose in the state of Georgia.
Are you aware that Donald Duncan, a leading critic of power control and cycle of violence models, published a series of books and articles critically reviewing these models, highlighting his findings being contradictory and data provided by the models that we're relying on?
Yes.
Are you familiar with his work?
No.
Are you aware of any other critics?
No.
Are you aware of any known potential error rate for these theories?
No.
Are these models typically only used in litigation purposes?
No.
So your theory of intimate partner violence presupposes numerous incidents, correct?
No. That is a definition. I gave a defined definition.
In order to make a determination that the cycle of abuse or power control exists, you would have to have evidence of consistent with the power control will.
It would be consistent to the definition. Because even though it may not be listed in this tool, it could be used. So we may not have everything here.
So you would, to support the power control, you would need history of different tactics used that are highlighted in this power control bill.
If I'm sitting with a survivor, yes. Not for courtroom purposes. We don't diagnose intimate partner violence in a courtroom setting.
No further questions.
Thank you, Ms. Rios. Ms. Beza, any redirect?
Yes, Your Honor. Briefly, we were asked questions on cross-examination about, potential victim with physical or mental disability.
Yes.
In your expert opinion, can someone with physical or mental disabilities also be an abuser?
Yes.
No further questions.
Ms. Rios, anything else? All right, questions from the jurors?
Yeah, you do that.
I do that. No, the jurors do that. I just facilitate it. Thank you, sir. Ms. James, can there be two abusers in a relationship? And by that, I don't mean could one survivor have in his or her orbit two people abusing the survivor, but instead two people are in a relationship and they are abusers of each other.
So no. If we go back to the definition, it's one partner who has a power dynamic over the other partner. So in an intimate partnership, there's one who has the power, there's one who does not. That's just like in family violence as well. There's a power dynamic when parents have power over their children. So no.
Ms. Beza, can you put State's Exhibit 56, that's the wheel, up, please?
Yes. Oh, the parental wheel, not.
Not the cycle, but the wheel. And not the throat.
Yes. Give me 1 second.
Ms. James, I'll start asking the question, but it'd be helpful, I think, for the jurors to see 56 again. But the question is, the items that are on the perimeter or outside of the wheel would be what would be externally visible that I could see in a relationship those two people have, whereas things on the inside would be what the public wouldn't see.
In a sense, yes, because the inside spokes, and also remember that the spokes on the inside is not illegal. So you wouldn't see someone getting arrested for calling their partner names, right? You wouldn't see someone getting arrested for using economic abuse, or you wouldn't see someone, even using children. You wouldn't, unless there's physical abuse or harm involved with those children, you wouldn't see anyone getting arrested or the public seeing this act. Usually the factors on the outside of, that's why they're on the outside, because these are very visible, right? Social services can be involved, and that's a very visible public act, right? So that's when I look at this wheel, that's why.
Can we put the wheel up?
So that you can see the outside is very much visible. But that doesn't mean that mental health is illegal. It's just very much visible, right?
I'm trying to put it up, Your Honor. It's contacting the server.
Oh, all right, technical issues.
Computer.
Thank you for your answer. We may get it up on the screen. We got one more question. You talked to the jury about how a single incident or maybe isolated incident separated by a significant amount of time aren't considered, and now I don't want to put words in your mouth, domestic violence, or maybe not the cycle of violence. Can you reconcile that with the notion that, well, someone can be charged with a domestic violence crime with a single incident? If I hit my significant other with a baseball bat in the face because we're having a fight, and that may be the only time we ever had a fight, that still can be characterized as domestic violence or intimate partner violence. But there seems to be a tension between the two things you talked about, and a juror, at least one, would like you to discuss
I can
that.
explain. So in the movement, we're defining domestic violence in a different way than statute. Now, statute basically says if you live under one roof, you're going to get charged with family violence. If it is with children, if it's intimate partnership, if it's parents, statute is completely different. When regarding statute and the laws is completely different. I can't diagnose domestic violence for law enforcement. They get to make that call. That's a separate thing. But when we're in the movement, it is a defined standard for us. And this defined standard is, I keep going back to the science, and it's research based, but I can see the confusion when it would be an isolated incident and they would get arrested for family violence. Now, like I said, we're talking about two separate things. That's statute. I can't control that. The movement can't control that. But the movement talks about the deeper science behind it. And that's why we make that separation. Did I explain it?
You said what you said. Ms. Beza, do you have any questions for Ms. James based on the things she just talked about?
Yes, Your Honor. And just to clarify, as one of the questions was timing between incidents. Is there a certain amount of, in your expert opinion, is there a certain amount of time that it has to happen between incidents for a person to be a victim of domestic
No.
violence?
No.
Can you further explain?
So on average, it takes 2 years for physical violence to appear, right? So we're talking about this period of what I want to say, what we talk about in the movement, where they're giving this person all of this love, attention, and the manipulative part, the grooming part, right? So the grooming part may take 2 years. There's no time frame on how these incidents happen. I've met with survivors where there's only been one physical incident, and that physical incident was enough for them to stay in that relationship for 20 years because they keep remembering what happened that day. So.
No further questions.
Ms. Rios, do you have any follow-up with Ms. James?
No, Your Honor.
Okay, Ms. James, thank you for your time.
Thank you.
Ms. Beza, next witness,
The state rests.
as forecast. Thank you, Ms. Beza. Ladies and gentlemen, we are at a natural break point because it's about 10:30, but we're also at a procedural break point when the state rests. There are a number of things I need to take up with the lawyers outside your presence, so this is a nice coincidence. We're going to take the morning break. It may be a little longer than 10 minutes because of the things we need to talk about. We won't make it shorter than 10 minutes. So I'll have Deputy Gordon start bugging you all around 10:45 on that clock, if we finish what we need to, but if it's a little bit longer, indulge us. And we'll go from there. Don't talk about the case yet. The state has rested. Bless you. The defense has an absolute right to present anything that they want to present at the appropriate time, which would be after this break. So they don't have to. But the evidence isn't closed yet. You haven't heard closing arguments. And of course, I haven't given you the law that you must apply. Thank you.
All right, for jurors.
Maybe the next one.
All right. We will give everyone, to include Ms. Rivers, a break, but I want to cover a few things first. Ms. Rios or Ms. Feely, I need to talk with Mr. Lawson in just a moment about his decision about testifying. But before that, anything from the defense? Oh, while you're thinking about that, let me get one thing on the record. One juror, the one who asked, well, two jurors asked, can both partners alternate in being abusers? There are going to be two abusers in one relationship. The second question from that juror was, in your opinion, does Ms. McCrary show signs of being a survivor of domestic violence? That was not an appropriate question, so I didn't ask it. We just didn't go out in the hallway to discuss that. All right, Ms. Rios, anything from the defense before Mr. Lawson and I talk about testifying?
Would move further the verdict on count two. The indictment alleges swelling in the blood lip, visible bodily harm. The evidence that we presented show the opposite, it shows no bodily harm. I know there was testimony for it, but in terms of actual evidence of swelling in the bloody lip and visible bodily harm, we would submit that there's not enough to go to the jury.
Okay. Ms. Beza, anything you want to say in response?
Yes, Your Honor. Not outside of witness testimony from Carmen, which is her daughter, and Miss Peggy, which is a mother, lead detective Dickerson who saw the bodily harm. In the EMT report, EMT Wheelis mentioned bodily harm to Ms. McCurry's lip. In addition, on the body camera footage, when Ms. McCurry was sitting in the backseat of the car, she says, "Look, he busted my lip, it's bleeding." On body camera, and Officer Farrow says, "Yes, I see it." And you can see it in the camera, and Exhibit 11 shows the bodily harm as well.
Okay, thank you. So as you all know, meaning the lawyers, Mr. Lawson may not know this, a motion for directed verdict is appropriate this time, but it's a real high burden that the defense needs to meet. I should direct a verdict of acquittal on a count only if there is no conflict in the evidence. And the evidence that there is, if you take all deductions and inferences from it, demands an acquittal as a matter of law. I don't know how strong the evidence is that there was, if we use the language of the indictment, swelling and a bloody lip, which would constitute, according to the state, visible bodily harm. But there is some evidence. And when there is some evidence, it's not appropriate for me to direct a verdict. It may be that the jury finds that it doesn't reach the level of beyond a reasonable doubt, and the instruction they're going to get on battery as to what constitutes visible bodily harm is it's a surprising, I don't charge it all that often, surprisingly high standard that the state's going to need to meet, where it's substantial swelling or substantial bleeding. And I don't know that the jury would find it, but the jury could find it based on all the things that Ms. Beza shared, multiple witnesses describing it as such. So it's a well-placed argument. I think that the evidence behind count 2 is trickier for the state than for count 1, but it is a count that ought to go to the jury, at least at this juncture. So the motion for directed verdict is denied. Mr. Lawson, ready for our conversation? Okay, I'm gonna need you to answer out loud to each of the questions I ask. Do you understand that you have a right to testify, and that if you want to testify, no one can prevent you from doing so? Do you understand that in the same way, no one can compel you or force you to testify? That is, you have a right not to testify. Do you understand? Do you understand that you, and not Ms. Feely or Ms. Rios, will be deciding whether you testify? Do you understand that if you choose not to testify, then I will be telling the jury that that is not a decision that can be used against you in any way? Do you understand that if you choose to testify, you will be examined, you will be questioned by your lawyer, but also by one of these prosecutors? Understanding those things, and I do find you understand all those things, do you want to testify in your case? All right. I find that Mr. Lawson has made his decision to testify with a full understanding of his rights, and he is electing to testify. Ms. Rios, do you have witnesses beyond Mr. Lawson that you intend to call? All right. We still need to have a charge conference. I think I'm going to need to give the jurors a long lunch. I have a lunch meeting for 1 hour on Zoom, so I'm going to be stuck back in my office, and that starts at noon sharp. So we may not get through Mr. Lawson's testimony. I'll let the jurors know when they come in that we have a hard stop a little bit before noon. And I'll just tack on an extra 20 minutes to the lunch hour so we can have the charge conference. The charge you received last night is unchanged from what you received, other than I've added the language on voluntary intoxication for us to discuss, but it'll be up on the screen when we have the charge conference. Ms. Rios, do you have anything else we need to cover before everyone else in the room takes a quick break? All right. Ms. Beza, anything else?
No, Your Honor.
All right. Why don't we be back in, is 5 minutes enough for you, Ms. Rivers? Ish? Okay, let's be back in 5. Let's be back by 10:50 on the clock here, so 7 minutes.
I've reviewed the charges and I don't think we have a ton that we disagree on. Would it be helpful for us to CC the state and send you our minor
Sure. If you send an email, then I can start processing it. And we'll go from there. I think it will be a very short charge conference. We need to do it before you do your closings. So your closings are going to be after lunch, just given what time it is. And it may be that Mr. Lawson's testimony continues on after lunch. I'm not putting any limit on that, but don't panic about, well, wait, I don't want to have to do any of my closing without knowing what the charge is going to be. All right. Thank you, everyone. Okay. Was it not on? No one said anything. Jurors? It's funny, I even thought to look, but I figured they would have said, what the heck? The issue last time is not now. It had gotten loose. I thought this talked to that. It actually talks to the podium. It's
I
that.
did too, that's why I said, I
it's
thought
the-
it was
They
connected.
must have switched it then.
Yeah, they switched it. It's the orange plug into that monitor. So if we ever get no signal, I'll test that one and then we need to wiggle that one, but it's good. It just had it turned off.
Yes.
Okay. All right. Break is over. We're back on the record in State versus Lawson. Ms. Besa, anything from the state?
No, Your Honor.
Ms. Rios, anything from the defense?
Yes, sir. Oh, wait. Just testify.
Oh, that's fine. But I'm going to ask you to call your first witness once the jurors come in. Anything we need to talk about outside the presence of the jury?
No, Your Honor.
Okay, let's bring the jurors in, please. Thank you, Deputy Gordon. You all can be seated. All right, jurors, welcome back. It is time now to have me ask Ms. Rios to call her first witness.
I'm very Lawson.
All right, Mr. Lawson, if you'd come on up, please.
Raise your right hand. Do you swear affirm that the testimony you'll give will be the truth, the whole truth, and nothing but the truth, so help you God? Glory and see. Can you state and spell your name for the record?
Mr. Larry Lawson. It's MRLARRYLEWSON.
Larry, where do you work?
Work at right now was a truck job. Now I work at a car wash and I also work at car for 2 jobs.
Mr. Lawson, I need you to get a little closer to the microphone. Unfortunately, it moves up and down, it doesn't move left and right. I mean, forward and backwards. So
I work at a truck job. I lost. I work at car for and I work at Dan's car wash.
sorry, I was moving my microphone. That created a little rattle as well. So one more time, tell us where you work.
At Carver's and at Dan's car wash.
You have any children?
Yes,
How many?
2.
How old?
I have one that's 11, about to be 12, and I have one that's 5, by Kenisa McCrary.
On September 7th, 2022, strangle Miss McCrary.
No, ma'am.
Punish Miss McCrary.
No, ma'am.
Press your forearm against her neck, obstructing her breathing.
No, ma'am.
Physically assault her in any way.
No, ma'am.
How do you know Miss McCrary?
I met her in 2018 at a job after I got divorced from my ex-wife. You know, she was staying at my house off and on, and she found some papers that I was a TBI patient and that I had a conservator, and she helped me get rid of my ex-wife. So she went through the whole process, and she supposed to be my conservator, Kenisa, but they said she couldn't be my conservator because we wasn't married.
How long did you live together?
We lived together approximately about 3 years off and on, because I had a home.
Jurors are having trouble hearing.
I said we lived about 3 years and a half.
Is it hard for you to speak up?
It's great.
Who else lived in the house with you and Ms. McCurry?
Okay, it was Carmen McQuarrie, it was Anthony Prather, also my son Aiden Lawson, and sometimes my other son would come over, and Diego Lawson would come over.
Would you describe the relationship you had between you and Ms. McCurry healthy?
At first, when she was working, and she was taking care of me because I got kicked out of my house because my wife found out about her and how young she was. She kicked me out, and I started depending on Miss Kanisa because she was helping me out through everything. But when she lost her job, that's when the relationship plummeted. In that same summer of the year I got shot.
What were the issues?
Issue was always about finances. She wanted to do this, do that, and I couldn't afford it because I was on a base income.
Because of your disability?
Yes, and I get a check every month for the rest of my life, but it's get balanced through my conservator. And she pays all my bills, including the bills that was at Kanisha house. I get the check of remaining of it. And I wouldn't want to do what Kanisha want me to do. The situation would start to get violent.
Who would get violent?
Kanisha would get violent at me, calling me bitches, hoes, she see my mama say she's a fat hoe. Your mama should have swallowed you.
Did Ms. McCurry ever physically assault you?
Yes. The same year, we was supposed to be going down to Orlando, 407, and I told her I didn't have all the money to go there. And she hit me, and she found out my secret. She hit me, and she found out my secret.
Secret?
Yes.
Can you explain?
I don't hit women. And then every time it started to escalate after that. She started pulling knives on me, jumping up and kicking. And I put my hand up in the air. You want to fight? I said, no, I don't want to fight.
How often did she physically assault you?
I said at least once or twice a month after the rent I got paid and the car loan I got paid.
It was nice to you until she got what she wanted.
Yes, it's something like that. And then I wouldn't want to do what she wanted to do. She would get aggressive. She knew I wouldn't hit her. Because my pops, before he passed, he told me, look in my eyes, told me to do two things in life. Don't never hit a woman. Okay? Because she gave you life and she make you duplicate. Okay? And never look box with a woman. Because she always got to have the last word. Give it to her. And I made that promise. I'm 50-something years old right now. I never hit a woman day in my life. Never been on my record. Never.
How often did she verbally abuse you?
That was awfully on occasion in the room and spare in the moment. Like I said, after all the bills get paid, that's when it comes. And then one time she'll kick me out. I leave, and then when time to come back, she's like, oh, I'm sorry, I did this and that. I will come back. We have a child again. I thought it was my second chance to be with her and have a family, actually, to have a family. And then with my car, my brother wrecked my car. I had nowhere else to go. I usually get in my car and just go down to Savannah with my brother.
We're dependent on her for transportation.
I was paying the car loan. And she wasn't even working at that time. That's when everything started going bad for us.
Send Ms. McCurry a text the morning of September 7th, 2022.
Yes, I did.
Your Honor, I have in my hand what has been previously marked as Exhibit 3.
Objection, Your Honor, self-serving hearsay.
This is a message that he sent to Ms. McCurry, and this is.
May we have a sidebar?
So we don't need to have a sidebar, but it's an out-of-court statement. And if you are offering it to prove the truth of the matter asserted, it doesn't matter that the declarant is here. It's an out-of-court statement. So if you want to ask Mr. Lawson about what was going on that morning, and did he and Ms. McCrary talk about things, at this point, that's how you need to go about it. And it may be on redirect after cross, there'd be a different basis for admitting that.
What did you say in the text message that you sent to Ms. McCurry?
I told her that I was tired of the physical, the mental, the verbal abuse, For her and her mother, who she had coming over my house all the time that I was paying rent at. She done spat in my face and bit me, okay? And I was tired of it.
When you say your house, Mr. Lawson, I want to make sure I understand. We've seen pictures and heard about apartment C7. Is that what you're calling your house?
Yes, I'm saying it was our house, but I'm saying I was paying the bills there, but I'm saying it was jointly ours.
That's fine. I just
Yes.
want to make sure I'm understanding the location you're
Yes.
describing.
So in the text message you sent her, you clearly indicated that you wanted to leave the relationship.
Yes, I wanted out of a relationship. And I hadn't paid the rent up for that month.
And what
And
were the
condo.
reasons,
And the car note, I paid the rent for that month and the car note.
what were the reasons that you wanted out of that relationship?
She was too abusive. She was a nice, nasty kind of individual. When she was up, she was a beautiful thing in the world. She gave me anything I want. When I was down, she did everything for me. Even took me to the same Sam's and asked me to marry her. But I told her I couldn't do it because my finances wasn't straight yet and I didn't want to enter into a bond. As a man, I can't take care of my family.
Do you remember what happened after you sent the text message on September 7th?
Okay, I came back to the house. It was silence. I went straight to the back, packed my clothes up. Okay. I called my ride. He didn't answer his phone. So I left him a VM. Okay. Later on that night, I went to the store to buy a calling card using her car because she usually turns her phone that she gave me on her T-Mobile off when it's time for me to leave or to call somebody. So I had to get a flip phone. Yeah. So
Tried to leave before?
yes, I tried to leave several times, but I had no transportation because my car had got wrecked inside Savannah. The only opportunity I had to get out of the relationship was use her phone. She shut off for me. So that day, last time she shut the phone off for me, I walked from Welcome Mall Road all the way to Jonesboro Road, which is an hour and some change to get me a flip phone.
The last time you tried to leave, she shut your phone off.
That's how I know she could do it. I didn't know that. She turned my phone off. I looked at it, I said, really? And I left out the house and I walked all the way to Walmart and brought me a flip phone. And I told myself this will never ever happen again. Then she came up to Walmart and came and got me, said she was sorry, this will never happen again, blah, blah, this and that. And I said, at the age, I had about 16 years. I said, she young, she in love. I said, mistakes happen. I gets back in the car, when I go back to the house. Okay, next month, my conservator does the same thing. She nasty again.
So going back to that day, you went and got a phone, so she wouldn't cut your, so you would have a phone if she cut it off. And you packed it back.
No. On the previous time I was getting ready to leave, she shut her phone off and I went and got a phone that day. But she came up there and got me telling me she was sorry. This never happened again. So I had retained the flip phone. For cases ever happen again, I have me a way to get out. Yes.
So going back to that day, what happened when you were at your home that you shared with Miss McBurney?
Okay, I walked in, I packed myself up inside the bag. Everything was solid. Later on that day, I went to Walmart to get me a calling card. Okay, I called my partner again. He didn't answer the phone. I left him a VM, a voicemail. I came back to the house. I sat down in the front room suite right there, living room suite. I sat down right there. Okay, Ganisa was coming from the back to the front. My phone rang. And he said he was on his way. I said, I'm going to the back to get my bags. I'm about to meet you at the gas station. Was up the street. It's not 2 to 3 minutes from up the street.
The he you're talking about, you keep referring to a partner.
Yes.
Who is this?
His name is Ernest Seabrook.
Okay.
He's a workout partner of me from New York. I know his family up in New York.
Partner like business partner or partner like this is a
Workout
good
partner.
friend of mine?
Workout partner.
Oh, workout partner.
Workout partner.
Okay.
So it was a workout partner.
Got it.
Ernest Seabrook, we from New York. We know some of the same people.
Can you tell me what happened?
So I sat down, she overheard the conversation. So she ran to the door and said, please don't go. I looked at her, I stepped up. The time I started to go to the back, by the time I got a little, recliner right there, she attacked me. We fell to the ground. Now I was tussling her not to hurt her, because I know if I hurt her, I'm going straight to jail. You see any marks on her. So as soon as I subdued her to a point, I said, look here, can we just stop this foolishness and let me go in the back, get my stuff, and go?
When you were tussling, she was attacking you and you were just trying to stop her from attacking.
That's all I always be. Okay? So I gets up, she gets up, runs past me, and go back to the back room. Okay? By the time I get past the children's room, I look in our room, I'm not in the room. She coming out of the closet with something in her hand. And as always, I'm taking caution because she always like to grab this gun, but she never pointed this gun at me. But this time, yeah, she didn't grab the gun before, but she never ever pointed it at me. So I told her not even to get this gun because she's too ill-tempered. Okay, all thing she can do is kill somebody that look like us or hurt somebody in this house. So I went to the back of the room. I seen her coming out with something in her hand. She looked back at me. So I stayed right there. I wasn't gonna walk past her because she might have something in her hand detrimental to me and get away because in South Florida, they don't do their job. So I stayed right there. She pointed a gun at me, told me, get out. I said, Kenisa, please let me go in this room and get my stuff. She came out in the hallway and said, get out, voicers. And then I backed up a little bit. I pulled out my phone, attempting to call 911. Next I heard, it was up. And I was on the other side of the hallway of the children's door. The door right here, I'm on this side. I'm bleeding. Next thing I know, I'm fumbling down. Next thing I know, I fell. Next thing, inside my left leg.
Can you show?
Right here. And the word,
And where was that? Where it hit anything major?
she had my homework. I got a problem in my leg for the rest of my life. And $150,000 bill.
How has that injury affected you?
It hurts. Like I can't really say it hurt like shut your mouth. It hurts. Hurts.
Every day you're in pain.
Every day I'm in pain. And I work 2 jobs, 18 hours a day. I was taking Marta. Okay? And I don't have time to take my medicine sometimes. So I be in excruciating pain every day. But I still find time to send her money. Every time she asks me some money, I'm gonna send my son his money. She's asked me for $450. I'm gonna send that money to her because she had my child.
Do you feel like she uses your child to control you in any way?
Objection,
did.
Your Honor, leading.
Overrule.
Yes. Like she told me that he needed $180 a week for debt care. But she also told me to text that he get caps in 3 weeks and told me to hold him at my own car for 3 weeks and she get caps. And I guess what I did? I still sent her the money. Because that's my child.
When you got shot, were you able to walk?
No, I had to go down. So my brother, he works at Memorial Sisters to Grady's. He gave me a discount down there. So I was catching the bus from here all the way to Savannah.
I mean, let me clarify. When you got shot that day, were you able to then walk? Like, what happened after you got shot?
After I got shot, I stayed still for a minute. Then I stumbled, then I slipped on my blood, and I fell down. That's what I was when they came and got me.
You remember going to the hospital?
Yes, I remember the paramedic talking to me, calling my mama, and I remember Kenisa said that something about drunk, and I asked the paramedic, say, please do an alcoholic test, a blood test on me, so I could show them that I was not drunk.
At some point, did you lose consciousness?
I was going in and out of consciousness in the house. And I don't know who tied that thing around my leg, but I thank God for them. Whoever did that, I would not be standing here right now. Whoever did it, I say thank you because you saved my life. They say that whoever put that tourniquet on my life saved my life.
Now, did you hear anyone going in and out of bedrooms? Did you hear?
Yes. I seen legs going in and out of the room. I seen legs coming here and there, but I was going in and out of conscious.
You have a drinking problem?
I don't drink.
Any reason you don't drink?
I'm a Muslim. Somebody called me Al Amin. My father's name was Al Amin. I don't smoke. I don't drink. That come from my T-bath sometimes when I get tired.
How does
Slurp.
your TBI affect you?
It makes me all balanced when I get tired. Sometimes I slurry. That's how I get kind of slurry, sluggish. But I'm no violent individual. I never been no violent individual in my whole life. I ain't never been no violent individual, especially towards a woman.
So you never pinned Kinesia down, Miss McBurney down on her bed?
Okay. I'm gonna tell you the whole honest the truth about that. That day that incident happened, it was because Carmen McCurry claimed that my son and her son jumped her. Also accusations that when she happened at her grandma's house, her other two cousins jumped her too. And I was laying in the bed sleeping, and they woke me from this here. And she told me to discipline my son. And I took him in the room and I asked him what happened. She said, "You're not gonna spank him." She continued to spank Anthony. And he told me what happened. And I told her, no. She said, "You're not gonna spank him?" So I turned to a ghost and no. Then she started hitting me. Okay? We fell on the bed. Okay? As we were struggling, I hold down and told her to stop. She spat in my face that day. And I called my uncle. She called her mother over. And her mother threatened me, telling me I'm gonna go to jail for holding her down. After her daughter got this spitting in my face, which I think constitutes as aggravated assault.
You were, again, you were defending yourself.
I was defending myself. I never put my hand on.
So don't talk over each other. You
Okay,
gotta wait
apologize.
till Ms. Rios finishes her question,
Okay.
and then you can answer.
Okay.
Now, after you were shot, do you ever remember talking to Officer Dickerson?
I ain't never seen. I thought it was a female.
Ever talk to Officer Burrell?
No.
Did any law enforcement officer come
No.
talk to you?
I've been inside the hospital for a whole month. I've been inside jail for a whole 6 months. I had a leg monitor on me for a whole year. That the prosecutor came and helped me get off of because she said, Kanisa said this only happened one time.
The relevance.
Only answer the questions.
Okay.
Ms. McCurry didn't know about your TBI injury.
Yes.
No further questions, right now.
Ms. Beza?
Yes, Your Honor. Mr. Lawson, let's start at the end. You were describing the incident in which you pinned Ms. McCurry down on the bed, correct?
So I didn't pin her down. We were struggling and I was trying to get her control of the situation. And she
You're trying
spat
to-
in my face. I was getting control of the situation. And when she spat in my face, I got off of her.
So she spat in your face to get you off of her because you were trying to get control of her.
No, I was trying to get control of the situation without hurting her or hurting myself.
Either way, you said it came about because Carmen came at your son, right?
No, I did not say that. I said that she claimed, she woke me out of my sleep, Kenise woke my sleep, claiming that my son and her son at the predator jumped her. And this story has been told again by her other cousins. Two cousins say that she said that they jumped her also. So I just grabbed my son to find out the situation before I do any discipline. Something that they're doing right now, I was gonna jump quote my son. I was gonna find out his side and his side, her side, okay? Once I grabbed her son, and he told the same exact story that my son Diego told, and I told her I was not going to discipline my son. And she got erratic and started hitting me. What am I supposed to do?
But Carmen was wrong.
Not Carmen, Kinesia, right? Carmen was wrong, but Kinesia was wrong also. She started hitting me.
Like Carmen, do you?
I like Carmen. I brought her shoes.
Carmen, the child Carmen is what I'm talking
I brought her shoes.
about. But you also yell at her, don't you?
No,
It's your testimony today that you never yelled at Carmen.
no, I have a loud voice. I never yelled at her.
So if there's a recording of you yelling at Carmen.
It's not a recording.
You?
Hold on, no, that's ejection. I'm talking recording of me doing what to her? I never ever dealt with Carmen. I always deal with the children, the men of the family.
You also testified on direct examination that you, when you were shot and you were bleeding out,
Yeah.
that you asked the paramedic to do an alcohol test on
I
you.
did.
However, you also testified that you never actually drank alcohol because you're Muslim. Correct?
I said I don't drink alcohol.
Because you're Muslim.
Yes.
So an alcohol test wouldn't even be an issue on September 7th of 2022, would it?
Wouldn't, because she said that I would drink it. I told him, give me an alcohol test.
Yet you're alleging now that you begged the paramedic or asked the paramedic to do an alcohol test on you when alcohol wasn't even an issue.
Yes, ma'am, because that's what she claimed.
Isn't it true that you only thought of this concocted story of an alcohol test from sitting through this trial and hearing witness after witness say that you were drunk?
If you go back inside and ask my lawyer, Jennifer Hansen, she would tell you I asked for a blood alcohol test inside jail, ma'am.
Now, you also stated on direct examination that Kanitia needed $180 a week, or you gave her essentially $180 a week money for daycare.
Not every week, but I gave it to her when I had it.
So she depended on you financially,
No, she didn't. She had her own money.
but you still gave her money,
I gave her money because she had my son.
and she relied on that money, correct?
No. We wasn't even staying together at the time. I was staying at my uncle's house.
Now, when you went through the story of what happened on September 7th of 2022, you were telling a story about how Kanicia attacked you and you subdued her and all of these things, correct?
I didn't sue nobody. I protected myself without hurting her.
But she was hurt, wouldn't you agree?
I didn't never hurt Kanicia.
Her lip was busted.
I didn't hit it.
You saw Exhibit 11, you saw the body cam footage, correct, in this trial?
I seen it by the camera, but you were speaking hearsay. Was you there? I was there.
And her lip is actually busted and bleeding. Wouldn't you agree from the exhibits that were presented to this jury?
Self-made, not for me.
Self what?
Self-made, not for me.
So it was self-made sometime between the shooting where she's helping you on the ground and her put in handcuffs, escorted to the car. Sometime in that time of helping you.
Help me do what?
she busted her lip.
Okay, repeat the question again, ma'am. You gotta talk a little loud. My ear kind of sharp, deaf in this ear. Speak a little louder.
You don't need to talk, you're plenty loud, just
Yeah, please go talk.
break it down into
Okay.
smaller
Yeah, I
pieces.
can't hear what she's saying.
Okay, listen up.
Maybe turn the other way and I'll speak in this ear, okay? Now, you're saying that she punched herself in the lip?
I didn't do it. I don't know how it happened. I didn't do it.
Oh, so you just don't know how it happened?
I got pictures in my hand though.
So now, do you remember, or isn't it true that, because you missed this part of your story that
So
you said on the stand, that you pushed Carmen out of the way when she was saying, get off my mom?
Carmen wasn't even in the room. They was in the room. Carmen wasn't out there.
So you're saying that Carmen's testimony yesterday about how she came out of the room and she was telling you to get off her mom and you kind of shoved her, she didn't fall, but you shoved her out the way, she made up that whole story?
Okay, she had plenty of time.
Just like you had plenty of time to make up
Plenty of
this concocted story you did
No,
today.
ma'am. No, ma'am.
Now, you also stated that, well, you said a lot of things, but one thing was that you were shot in the hallway, you stumbled down the hallway and fell in the living room.
I slipped.
Slipped
I slipped.
on your blood, right?
Yes.
Shot in the hallway,
Shot in the hallway.
stumbled down the hallway, that's that blood in the hallway,
Yeah, I stumbled down there.
and you fell in the living room.
I fell. I don't know where I landed at, but I fell.
Fine. You saw the pictures, correct? Would it be safe to say you landed where that pool of blood and towels are in the living room?
I didn't really recall that, but I'm saying you could say that. I don't know where I felt that.
Mr. Lawson, do you realize that the physical evidence in this case goes completely against what the story you just told?
No, I don't.
Okay, well, let's go through the physical.
Let's go.
You do realize, and isn't it true that the shell casing that was recovered inside the bedroom in the corner by the window?
I wasn't shot in the room.
Okay, and isn't it true that but there's blood located in between the TV stand and the bed in the bedroom?
That is not blood. That is wine that had been running for long periods of time. If it was blood and I got shot, there wouldn't be a trail of blood from that spot all the way to the door. I got shot in my main artery, ma'am.
So now it's wine. This is the first time
Hold
we're
on.
hearing about wine.
No, I'm telling you what that is on the floor. Y'all doing speculations of this thing. The officers didn't do their job. I did not get shot in that room, ma'am.
Isn't it true that Tanisha, with what the physical evidence shows, shot you as she was in the corner, the bullet traveled through you into the TV stand, and you stumbled out of the room? You can follow the blood. Mr.
No,
Walker.
ma'am. I didn't get shot in the room at all. I got shot in the hallway. She came outside of the hallway and shot me.
So despite the physical evidence disproving this story you're telling, you're gonna stick with your story.
Ma'am, I'm telling you what happened that night.
You do realize there are no shell casings in the hallway, right?
You realize that the officers didn't do their job. They didn't come see me at all.
Do you realize that there are no shell casings in the hallway?
I don't know, because I know the bullet came out of my leg, though.
You're right, it came out of your leg into the TV stand.
No, it came out of my leg. Tell me he had scratched it out of my leg.
Convenient, Mr.
No,
Walker.
ma'am. Ask the doctor.
Don't talk over each other.
I
and
apologize.
Don't comment on his answers, just
I
ask
apologize.
questions.
Yes, Your Honor. Now, next question, in the beginning of your testimony, since we are working backwards, right? So now we're at the point where you said it's at that same Sam's Club that she asked you to marry her. You remember saying that in your direct
It's true.
examination?
True.
And was this the Sam's Club in which you left that one time and drove erratically all the way home to scare her because you were unhappy? And
That never
tried to
happened.
talk to her?
That never happened.
So that's made up too.
It's all made up.
Okay. Now, you testified that you paid rent, you paid car notes, you paid
Like a servant.
for Canisia's lifestyle, correct?
No, my conservator paid the bills on my half for me staying there. I didn't pay Canisia a bill. She paid my half of the bills there.
But you did use her car, right?
Of course, I was paying half of the bill.
And you were trying to use her car even when she didn't want you to use her car the day of the incident,
And then I had
correct?
somebody come at the gas station to come pick me up.
Right.
She had her car keys.
Okay, you had someone, the random person named Ernest
Seabrook.
Seabrooks.
Seabrooks.
Got it. Now, you mentioned that when your attorney, you sat through the trial, correct?
Of course, ma'am.
And when your attorney was asking Ms. McCurry to meet your question on cross-examination, she mentioned, but you did not mention on your examination, that you gave her money while you were in the hospital, right?
So she requested money. I got a text message. She requested money saying that she didn't want to go back to her mom's and pops.
And you gave it to her, correct?
Of course, she is my mother of my child.
And this was another time or one last time that you were exerting your power and control over her by supporting her financially, correct?
No, I wasn't even living with her.
You knew she depended on you financially.
No, I didn't.
But yet you still gave her money
She has my child.
all of the time, correct?
She has my child. I'm gonna always give her money till the day I die because she has my child.
Now, you started your direct examination with you did not strangle her, you did not punch her, you did not obstruct her breathing, you did not assault her in any way, correct?
Correct.
So this is your testimony today that the physical evidence actually on the scene, Carmen, Canisia, everyone is just making up this story,
Yes.
right? No further questions.
Ms. Rios, do you have any redirect for Mr. Lawson?
No, Your Honor.
Okay. Are there questions from the jurors for Mr. Lawson? All right, Mr. Lawson, you can be at ease, as can the jury. Will be back in here in a little bit.
I can move. Yes, I can go to the restroom. Thanks.
You described receiving at the hands of Ms. McCrary.
No, sir. I'm a man. I was kind of feeling kind of embarrassed because me letting a woman beat on me and then call it in, that sounded absurd to me. But I never knew it would go this far.
Can you tell the jurors what you mean when you say TBI?
I've been in a truck accident. I mean, traumatic brain injury.
Okay, traumatic brain injury is
Traumatic-
TBI.
She bought.
Do you receive benefits for the TBI?
Yes, I do.
Something like SSDI,
No, I got a workers' comp claim that they went through.
workers' comp. So when you're saying you get money every month for the rest of your life, it's through the workers' comp settlements. Okay. Are you working right now?
I was forced to work because as Kanisa had informed me that my ex-wife was stealing all my money, that she helped me get rid of her. And she supposed to be in it, but they gave me another conservator and she doing the same thing, stealing all my money. So I'm getting pieces of my money every month.
So you covered a bunch there, but I'll ask, your ex-wife used to be your conservator.
Yes, yes.
Then you got a new conservator, who.
Lou and Bonnie, and she is doing exactly the same thing. She is stealing my money too, but sending me partial money. Matter of fact, I got a check that she just sent me inside my bag if I can go get it.
Okay, no, you don't need to do that. And I think that was your way of answering, you're being forced to work because you are telling the jury you're not getting all of your monthly payment.
No, sir. It's written inside my agreement. I don't supposed to be working at all.
Okay, but what about the working at the car wash in Carver's? That was what you were doing at the time of the incident, or that's what you're doing today?
That's what I'm doing now today.
Okay, so then let's get back to my question. You are working now,
Yes, I am.
two jobs.
2 jobs.
Okay, how many hours a day?
18 hours a day. By the time I take Marlon to get from my uncle's house, it ended up to be like a 21 to 22 hour day for me.
Okay.
So I'm getting like 2 hours sleep and I have to take my pain medicine, the Percocet they give me for pain.
So you mentioned that you explained that you have not reported to the police, did not report to the police any of the abuse you allege Ms. McCrary did to you. You explain why. Did you ever seek medical attention for anything Ms. McCrary ever allegedly did to you?
No, I never did because at that time I was in love with her. She done did so much for me. I ain't gonna lie to you. When I was down, she did everything for me.
Okay. The evening of the incident that brings us all here, did you have the keys to Ms. McCrary's car at any point?
I had it at first, but then she gained control of it when I was in the house. I gave it back to her. She had control of the whole car. Thanks. She had the car keys.
Okay, so you had used the car keys to use the car to, I think you said to go to Walmart to buy a
Walmart.
calling card?
I called a card from my minute phone in case she had stopped the activation on the T-Mobile card that she
Okay,
had on her plan.
and the incident that we've been talking about and the 911 calls were all around 7:30 in the evening that day. How far before 7:30 would you say you came back with the car keys and your calling card?
Came back, it possibly had to be like 7:01, 7:02, something like I came inside the door.
Oh, I'm not asking you the exact time, but about a half hour before the situation
Before
happened?
it happened, and I came inside the house and I sat down right there waiting on him to give me a call back because I left a VM on his voicemail.
Mr. Seabrooks?
Mr. Seabrooks.
Okay.
Then when he called me, she overheard him when she walked up. And I said, I was on my way down to the gas station.
So did you, after you got back to C7, having got the calling card, did you ever go into your bedroom and change out of your street clothes into your pajamas
No,
while you were waiting for Mr. Seabrooks?
no.
Okay. How was it that the keys, which would have been on you when you came home, ended up, you said that Ms. McCrary ended up, I think you said, in total control of the car. I mean, she had the keys. How did the keys get from you to her after you got home that night?
I set them on the key stand right there by the door. I set it right there. And she came up. She, like I say, she had possession. She ran to the door and she had possession of the car keys.
Okay.
And I didn't need the car keys because I was walking distant from the
Tell
window.
the jurors why you went back towards the bedroom where Ms. McCrary had run just before you got shot, as opposed to staying in the living room waiting for Mr. Seabrooks to call you.
That because I had my clothes inside there. I had my clothes already packed inside there. When he called me, I went back there. I was going back there, but she stopped me. She ran to the door and said, please don't leave. Okay, then I was going to go back there to get my stuff, but she attacked me and fell on the ground.
Okay. And then eventually you guys separated, and who went into the bedroom first?
I was going towards the bedroom first. She got up and ran past me.
Okay.
Okay, so I'm thinking this is another futile attempt for her to make me stay. Okay, so when I got back there, she coming outside of the closet with something in her hand. I looked in the room and she looked back at me. I said, my clothes inside there. So I'm not gonna walk past her because she done had a gun before. And sure enough, it was a gun. She pulled it out on me.
Got it. And you were shot while you were standing in the hallway.
You know, she came outside the room and shot me.
Got it. So not only were you in the hallway, Ms. McCrary was in the hallway as well. Neither of you was in the bedroom when the gun was fired and you were hit.
I was hit. I was not inside the bedroom.
Okay. And tell the jury what you remember about Carmen, so Ms. McCrary's daughter, trying to get involved, maybe break up the tussle you two were having when you fell to the floor.
She wasn't even around. Jerry, she wasn't even around. They was inside the bedroom. All the children was inside the bedroom. She wasn't even around.
Was the air mattress, you may have heard there was some testimony about an air mattress that you used to lay on if you were watching some TV out in the living room. Was that out there the night all this happened?
It was, but what happened was that we had stopped sleeping together because she got so volatile about me buying her a king size bed to go inside as a queen size. So I wasn't gonna do that. So me and our son was sleeping inside the front room. It went on for like 2 to 3 months and we haven't slept together.
Okay. Ms. Rios, do you have any questions for Mr. Lawson?
No, Your Honor.
Ms. Beza?
Yes, Your Honor. This, isn't it true that your TBI or traumatic brain injury happened in 2002?
The truck accident happened in 2002. I became official TBI individual inside 2012.
So
You said 2012?
That's when they officially recalled me as a TBI patient. I had the card. I got the Fulton County statement downstairs.
So 12 years ago.
Yes, 12 years, probably 13 now, 25.
Now, Judge asked you about a question from the jury where you were going to Walmart, and you said that you went to Walmart in case she stopped your phone, correct?
84, yes.
Isn't it true that day you were out drinking, you actually didn't go to Walmart
I don't drink, madam.
or back? Now, you testified with that Kinesia ran past you right before you were shot.
I got a text message that's on there, if you would like to see it.
Ran past you in the hallway, grabbed something out of the closet, and you were shot in the hallway, correct?
Yes,
You were sitting in court here today when Carmen testified, correct?
correct.
And you heard Carmen say that she heard from in the bedroom, her mother go in the room locked the door and she heard you doing something in the kitchen and picking the lock, correct?
I heard her say that. But can we go back to the actual police statement? Because she never said it. First, she said, I followed her in the room. Okay. Then she put a gun and shot me. Then she locked the door.
Don't interrupt him.
Yes.
If you want to object to something, you
Yeah.
can, but he's going where he's going and you
I'm
can
saying-
follow up.
I'm saying in the second report, she said that I followed her and she tried to lock the door. If you want to have a refreshment of this report, and I pushed it in and came. And then the last one, she said that I picked the lock of the door.
Whether you pushed the door and picked the lock, I'm talking about Carmen, the child, right? You heard her testify in court, correct?
Correctly.
And what you're saying today is that Carmen is just making this up, that her mother went in the room, locked the door, and she heard you playing with her, picking the lock. That's all Carmen just made up this.
That's a
story.
lie. And also according to the report, that is a lie. That's never been mentioned inside the report at all. Can I refresh your memory? Can I go over there and get the piece of paper, ma'am?
You may not, if someone wants to refresh your recollection, they can do that.
Okay.
Now, it's also your testimony that no one was in the bedroom, not you, not Tanisha, when you were hit, when you were shot, correct?
Correct. She came out of the room.
Despite the shell casing being in the bedroom, despite reported blood that law enforcement saw being in the bedroom, your testimony is no one was in the bedroom.
Was that blood that they examined?
Is that your testimony?
Yes, it's that blood that they examined, ma'am.
You need to answer her question rather than asking her questions. Okay.
Now, my last question is, you said that you were packing your things in a suitcase. How big was the suitcase? What color was the suitcase? Was it a suitcase or was it a
So
bag?
let's do one question at a time.
What were you packing in?
I was packing inside a luggage bag about this big,
And what color?
suitcase.
What
It
color
was
was
like
that?
a teal green.
Steel green bag?
I still have it.
You still have the bag. And how big was the bag? I'm sorry?
It's like a luggage bag.
The small, medium, large,
It's large.
large bag. And where was the bag?
Inside the closet where Kanisa went back there and could retrieve the gun from.
You were packing in the closet and you kept the suitcase in the closet instead of bringing the suitcase, say, to the front door because you were leaving.
No, I packed the suitcase earlier when I came back from the gym. And everything was calm. I walked past her. She spoke to me. I never spoke to her the whole entire day. I packed my suitcase up early that day.
And left it in the closet as opposed to putting it on the floor, putting it by the door because you were leaving. You left it in the closet.
I called my individual, Ernest Seabrooks, and asked him, could he come get me? I had to leave a voicemail. I didn't know he was coming to get me.
Did you leave the suitcase in the closet the whole day after you packed it for some reason?
Yes, I did.
No further questions.
Yes, I did.
All right. Mr. Lawson, thank you for your time. You can return to your seat.
Thank you so much.
Ms. Rios, next witness.
Defense rest.
Ms. Beza, well, we need to break for lunch, ladies and gentlemen. The defense has rested. I need to talk with the lawyers about a few things, and the lawyers and I need to have a conference about the jury charge, the law that I'm going to give you later this afternoon. That conversation takes a little while, and I have a lunch Zoom meeting that I need to be on in about 2 minutes. So I'm going to go do that. What that means is we have to extend your lunch break a little bit because we're going to have this charge conference when I get off my meeting. So I know we had talked about shrinking your lunch because an hour was more than enough for everyone. But we are now very much ahead of schedule. The defense has rested. I'm going to talk with the parties about whether there's any rebuttal evidence. If there's not, then the evidence is closed, and all that remains would be closing arguments, the summations from the lawyers, then my charge to you, and then you'll be beginning your deliberations. So I suspect you'll be doing that this afternoon. I'm going to ask that you all be back by 1:20. You may still wait a little bit after that. I think that's going to be enough time for me to finish this meeting and for us to do our charge conference because the lawyers have already done some homework on that. It feels weird apologizing for extra time, but I know you're all anxious to keep this moving along. The way the evidence has unfolded, there's not other natural break time for the charge conference. We normally would say, it's 4:30, let's end for the day, send you home, and we do the charge conference then. But we couldn't do it till the evidence was closed, and here we are. So lunch is your time. You can eat as a group, as small groups. Just don't talk about the case. Even though the evidence may be closed, you don't have the framework in which to place it, i.e. the law that I give you. and you haven't benefited from or sat through the lawyer's closing arguments as they attempt to persuade you that this is what the evidence has shown or failed to show. So resist that temptation to start chatting with each other about how this case is sorting out or not sorting out. You'll have plenty of time to do that when you deliberate. Any questions about lunch? All right, if you take your notepads, go to the jury room. We'll see you at 1:20.
All rise for jury.
All right, you all can be seated. Ms. Beza, anything before we break for lunch?
Not at this time, Your Honor. I may have one rebuttal witness, but I'm going to think about it during the break.
Okay, I appreciate you doing that. Just based on how Mr. Lawson's testimony went, I suspected that could be a possibility. Please let Ms. Rios and Ms. Feely know as soon as you decide if you're going to be calling someone so they have a chance to react to that. Would it be someone who already testified?
Yeah, it would be Kinesia McCrary in regards to a recording that she provided during the trial, so it wasn't before trial, about with him yelling at the 12-year-old.
Oh, okay. Well, if you are going to do that, make sure you talk. Okay, what? Let's cross the bridge if that bridge presents itself. Ms. Beza is going to think through it, and she may conclude that the case is at an adequate resting point and not. But as I requested, if you are going to go forward, share as much info as you can with the defense attorney so that when we reconvene at 1, which is when we're reconvening, we'll address that first, and then we will dive into the charge conference. Ms. Feely, if you're able during lunch, I don't mean to make you work during your own lunch, to send an email to everyone saying, here's our concern with the charge, what's in there or not in there. That would be helpful. I still think we'll be able to get through it all if you all could be ready to go at 1. Anything from the defense other than both you pretty much exploded when you heard about a recording?
That's it.
That's it? Okay. Thank you, everyone. We'll see you at 1 o'clock. I will mute things here so you can stay in here if you want to talk. All right. Better? Okay. Ms. Rivers, are you ready? Let's go back on the record in State versus Lawson. It is a little bit after 1. And Ms. Beza, did you decide over the lunch break, not that you necessarily had lunch, what you plan to do in terms of rebuttal evidence?
Yes, Your Honor. So the state has a recording in which you may not have the correct witness to introduce it at this point. It's a recording that LaTanya Hopper got from her niece, Carmen, of the defendant screaming at her. LaTanya's not here. We have Kinesia here who can identify both the voices, but I'm not sure she can lay the proper foundation as she can only know via hearsay or guesstimate when the recording was. But she does know it's the defendant's voice, and she knows it's her daughter's voice. She knows when LaTanya sent it to her. That's about it.
Okay, but otherwise, it's hard to pinpoint when the yelling happened.
Correct.
Okay. All right. So given that, what's your plan?
My plan is to see if there's an objection to the recording and then decide whether or not I'll put her on the stand to testify as to just the recording, not rebutting everything the defendant said. I'm not going to re-victimize her. It's just this one recording.
Okay. Have you, Ms. Rios, had a chance to, did you question Ms. McCrary when she testified? You guys can divide it up however you want, but have you had a chance to listen to the recording?
Yes.
Okay. And you just got it today. It sounds like the state just got it today, but it's also rebuttal evidence. And so query what the discovery rules are on that anyway, but it sounds like the state just got it.
Yes, sir.
Do you have an objection to it being admitted as evidence and then published to the jury through the witness, Kanisha McCrary?
Yes. We both have an objection to it being introduced to that witness.
You only need to, only one of you needs to object, and you can do it, but it doesn't need to be that you both object.
So we object both to the lack of being able to authenticate it, and also I think it wouldn't pass the 404, 403 analysis, which the court would have to hear first, but
How long is it?
it's not very long, but it's, the probative value is very much outweighed by the prejudicial effect.
Because of what's being said?
Just the fact that we don't know any context at all, it's just yelling on a voicemail or whatever it is.
Okay. It seems like it's probative because it would, if it's what people say it is, it would directly contradict something Mr. Lawson said. And so that makes it to me seem like it's pretty darn probative. But only if we're confident it is what people say it is. And so that's why the probative value might drop.
And I only listened to it once, but it wasn't really clear who was yelling who. It's just a voicemail yelling, and so.
Okay, so there was, everyone's voice was loud.
You couldn't even hear who was who. You could hear it was a deeper voice in the background and in another, a female voice, but you couldn't make out what anyone was really saying, especially the male voice.
Okay, so it was just loud voices, but not intelligible voices.
Yes.
Not, you better go to your room, but just loud.
Yeah, I couldn't hear, but make out what the person was.
Okay. Do you want to play 30 seconds of it?
It's only 18 seconds,
The whole thing?
Mhm.
Why don't you play the whole thing?
17 seconds. Actually.
I can't read it. I take a minute. I'm not talking to anybody.
Can you play it again, please?
Yes, Your Honor.
I can't read it. I take a minute. I'm not talking to anybody.
Okay, you can stop it. So if it's admitted, we just play the first 10 seconds. The remaining 7 seconds of the female crying don't go to someone yelling. And so I don't think the jury would need to hear that. Is it your understanding, Ms. Beza, that Kanisha McCrary would be able to say, that's my daughter's voice and that's Mr. Lawson's voice?
Yes.
Okay, she's had an opportunity to hear this.
Yes, Your Honor. And today she signed this CD. I got the recording yesterday, 12:54. I sent Ms. Rios the forwarded email.
Okay. So Ms. Feely, talk me through your 403 analysis. I think the mother of the child and the multi-year significant other of your client is someone who could get it admitted. And then one could argue the weight that should go to that. I also think it's particularly probative of Mr. Lawson's statement to the jury. I didn't mess with the girls. I took care of the boys. And if someone was going to fuss at the boys, it would be the boys. I don't yell. I didn't yell. This contradicts that. And it sounds like Carmen is upset. We don't have the context as to why, but she's upset. And it is inconsistent with a picture that Mr. Lawson very effectively painted of how he interacted with members of that household. So I think it's probative. It is prejudicial, but assume for a minute, Carmen McCrary was the one through which the state was admitting this. I'd let it in the face of a 403 objection. And so I want you to put it on the record and help me understand, how does that change, other than that it's slightly less persuasive to have the mother of the girl whose voice is on there and the long-term companion of the other person whose voice is on there saying, this is who's talking. Not what they're talking about. The jurors will make of it as they will. The thrust that I got from Ms. Beza is, it's not so much the words as the tone and the volume, which isn't consistent with the picture that Mr. Lawson painted.
I mean, I think, I can't really tell who he's yelling at. We can hear that the child is there, but I couldn't make out any words
Okay.
that would suggest he was yelling at her.
Okay.
Certainly an inference can be made, but again, that goes, how probative is it if it's just him yelling in the background?
Okay.
If it isn't him yelling.
Got it. All right. Your concerns and objections are noted. Ms. Beza, if you are calling Kanisha McCrary back to the stand, well, you can ask her other questions if you want, but you're saying what you're going to talk to her about is this recording, how she obtained it, whose voices are on it, and then you'll tender it. There'll be an objection to things we talked about outside the presence of the jury. I plan on overruling that objection at this point, but if Kanisha McCrary says, I have no idea, the DA handed me this recording and I listened to it, that's a different foundation.
Correct.
But I'll let you play that, and you'll need to stop it at the 10-second mark. And that can be states X, whatever number it is.
Yes, Your Honor.
Okay,
And then the authentication objection is also overruled.
correct. I mean, we'll need to, authentication and foundation are intertwined. We'll need to hear the testimony, but if the testimony is as forecast, someone who didn't make a recording can authenticate voices. People do that all the time with jail recordings. I know who that is. That's Trey.
There's not gonna be any editorializing about when this was or any speculation, like, she doesn't get another bite at the apple to just start saying bad things again, right?
Well, I leave that up to Ms. Beza as to what she wants to explore. Mr. Lawson said things in his testimony that I think opened the door pretty wide to Ms. McCrary talking more about the nature of their relationship. I didn't hear Ms. Beza said that's why she's putting her back on the stand. What I heard was the state's relying on the record that was made during their case in chief, with one exception. This call, which would be to rebut Mr. Lawson's claim that he didn't yell at kids in particular, he didn't interact with the female children. My words, not his exactly, but that was the gist of it. Okay. Am I saying anything different than what you intend to do, Ms. Beza?
No, Your Honor. Limited to the first 10 seconds and her identify the voices.
Okay.
I'm gonna go tell her, Your Honor.
Okay, can we do can your investigator tell her and we can do the charge conference?
Yes, Your Honor.
Great. All right, you should have on the screen now, the jury charge. Get this out of the way, there. And I'm gonna scroll through to the areas where I had questions. If I go past an area where you have a question or concern, let me know. And Ms. Feely, I did get your email, thank you, that's very helpful. And I think I'm gonna incorporate, I haven't yet because of the call I was on, but I think I'm gonna incorporate exactly what you asked for, but we'll get there. All right, let me see if I can make this move. All right, I will not give the charge on a defendant not testifying because Mr. Lawson did testify. So let me strike through that. I think you said in your email, you do not object, Ms. Feely, to removing mere presence. That's not this case.
Correct.
Okay. Ms. Beza, any objection to removing mere presence?
No, Your Honor.
Okay. Voluntary intoxication, which you'll see on the screen, was a later addition from the state. I massaged the language a little bit, but that's the thrust of that charge. I think it fits in this case based on evidence that's been presented. Ms. Feely, any objection to its inclusion?
We would object simply because we aren't saying that because he was drunk, he should be held accountable. So that's-
Sure, you're saying he hadn't had anything to drink at all.
So we don't think it's that.
Okay. I think it's something that jurors could still wrestle with. And so I'm gonna leave it in there. I'm taking out the self-defense. I don't know who requested that, but,
I did, it was just,
well, it's certainly, it might be something that the state would want to talk about if they were somehow having to defend Ms. McCrary's actions, and they may need to be explaining them, but I don't think it fits in this
Yeah.
case because of course the person on trial now is Mr. Lawson and not Ms. McCrary. In the future, that may switch around and then self-defense might fit, but your defense is not that he used deadly force to protect
yeah, I guess
himself.
my thought process is like tussling, and she fell, and she's, like trying to get her off of him, and that, it wasn't clear, but yeah.
Okay, you're all right if that comes out?
Yeah.
Okay, those were the only edits that you saw in there. Let me go to Ms. Feely's email. Okay, intent. Ms. Feely is asking that on that first sentence on the charge on intent, I add and must be proven beyond a reasonable doubt, which is a legally correct statement. I tend to lop that off here and there because it's in almost every charge. And of course, the state has to prove everything beyond a reasonable doubt, except like some weird corroboration exceptions, which isn't what we're dealing with here. I don't mind putting it in, especially given the way this case has played out. Do you have any objection to that, Ms. Beza?
No, Your Honor.
Okay. Ms. Feely, anything else?
That's it.
Ms. Beza, did you have any concerns about the charge?
I do not, Your Honor. I read them yesterday.
Okay, great. Then I'll make those edits. You all will get a hard copy, one per side of the final version. A hard copy will go out with the jury for their deliberations. And if I'm able to, we'll also have up on the screens the text as I'm reading it to them. Ms. Beza, anything else before we bring the jurors in?
No, Your Honor.
Are you ready? Are you going to open and close in your closing?
No, Your Honor. I'm going to just do one closing. Yeah, my
At the-
PowerPoint is being weird, so one closing at the
Okay,
end.
at the end. So Ms. Rios or Ms. Feely will go first.
Yes, Your Honor.
Got it. Okay. So which one of you is doing the closing? Ms. Feely, are you ready to go with your closing once we're done with Ms. McCrary testifying again? Do you need any setup time or can we pivot right into that?
It's my IT person, so I'll defer. Do you need to get it hooked up?
No, because there's no.
And I'm gonna go see if the witnesses are
Just a
not.
quick break. Between her.
Yeah, just to make sure.
You know.
Okay, quick, like we need to excuse the jurors or just say 1 second? Because they're only going to be in here for like 5 minutes. Why don't you try getting it set up now? And it could just basically be ready to go. And I'll take this off the screen. I assume they're ready? Okay.
Try something.
If there is.
Let's try this out. Resume.
Hey, Ms. Primovic.
Hey, good afternoon, sir.
Good afternoon. Are you working with Ms. Wood?
Yes, sir.
How's that one going?
We're gonna close, charge conference at 1:30, and then we're gonna close.
Wow. Okay.
No messing around down in 1D.
No, other than jury selection.
I'm gonna go see. You think?
They're good?
Yes.
Okay. Did the bathroom ever get fixed?
That was like, it was earlier today that it was him.
Oh,
They were fixing.
okay. I hope it's fixed. Allegedly.
Okay. Does she really use? Does she use? Yeah. So we have to put out the same. Yeah, is she gonna use it for the sort of rebuttal? She's actually gonna use it first. Oh, right, the rebuttal was.
Asia, are you using Zoom for the rebuttal
Yeah,
witness?
it was fixed.
He said allegedly.
Okay.
You heard? So you should have to hold it down.
Yeah, all right. But it's not like overflowing or anything. Okay.
Yeah, start from the beginning again, and then I
Good.
try to present thinking how to do something different.
I'm so sorry. I did this. I don't know what's wrong with my.
Spirit and Project Strong, the final one.
Hmm?
The final one instead of,
Share with you.
yeah.
See. Copy and it's. Share with you. Did I yours? I gave you access. I'll be here, but. Yeah. Okay. I'm gonna send it again. Let me send it one more time. Try opening that one. Opening the one I just sent you. And see if you can open it in your PowerPoint.
Ms. Rios, we good?
Yes.
All right. Can we bring Ms. Beza, is your witness ready?
Yes, Your Honor.
Okay. So Ms. Rios, we can bring the jurors in?
Yes, Your Honor.
Okay, let's do it.
So how can you save it on your computer? File save as and then open it. Yeah. Then you go. Then. Oh, that's good. Okay, well, while it's downloading, let's see if you can try that. Control. Okay. Let me see something. Let me see if it works.
All right, for the jury. She needs a spot.
Okay, let me say something. I think that is not working clearly. So. See the bottom.
All yours, the president of the county court.
Thank you, Deputy Gordon. Everyone can be seated. Ms. Beza, does the state have any rebuttal evidence?
Yes, Your Honor, the state calls Tanisha McCrary.
Right.
What number are we on?
Yeah. Now, it's one.
We should swear her in again, just as a different day.
Thank you, raise your right hand. You swear affirm that the testimony you will give the truth, the whole truth, nothing but the truth, so help you God. Really, I see. You state the spelling name of the record.
Kanesia McCrary, Kanessia McCrary, McCrary.
Hi, Ms. McCrary, how are you?
I'm well, how are you?
Okay. Give me 1 second. Prior to you being called as a witness today, or right now, did you have a chance to listen to a recording?
Yes,
And did you recognize, how did you obtain that recording?
from a relative, from Latanya.
LaTanya Hoffer, your sister?
Yes,
And in that recording, did you recognize any voices?
I did.
Whose voices did you recognize?
Carmen and Mr. Lawson.
And did you have a chance to listen to that recording and sign the CD?
I did.
I'm coming up and handing you State's Exhibit 78. Do you recognize State's Exhibit 78?
Yes,
Okay, and what is on that CD?
my signature.
And is this the recording that you had just testified to?
Yes,
And did you listen to this recording in full?
I did.
And did you recognize the voices that you just stated?
Yes, I did.
Your Honor, at this time, the state moves State's Exhibit 78 into evidence.
Ms. Rios, beyond the foundation and relevance arguments that you raised outside the presence of the jury, objections that you made outside the presence of the jury, which are preserved and carried over to now, do you have any other objections to the admission of State's 78? Okay, it's admitted over those objections.
Publishing at this time. I'm going to stop at the 10-second mark.
I can't read it. Can I take a minute? I'm not talking to anybody.
For the portions that was just played, the first 10 seconds, whose voices were those?
My daughter Carmen and Mr. Lawson.
No further questions.
Ms. Rios, do you have any questions for Ms. McCrary?
No, Your Honor.
All right, any questions from the jurors? Seeing none, thank you for coming back. Ladies and gentlemen, the evidence is now closed. You have heard all the witness testimony you're going to hear and received all the exhibits that you are going to have back in the jury room. It is time for the lawyers to make their closing arguments or summations. They will be trying to convince you to decide the case in one direction or the other, and you should feel free to be persuaded by them. But keep in mind what I told you at the outset of the trial. What the lawyers tell you is not evidence. You decide what happened in this case. These are persuasive advocates, but again, you're the fact finders. They are not. The state has the burden of proof, as you've heard me say a bunch, as I'll tell you more in a little bit when I give you the charge. That gives the state the opportunity to both open and close with closings, kind of to bookend whatever argument a lawyer for Mr. Lawson might make. Ms. Beza has shared with me that she is waiving her opening, so you're actually only going to hear from each side once. And Ms. Beza is reserving her time to go after a lawyer for Mr. Lawson presents that closing. I think Ms. Feely is going to be giving the closing. So Ms. Feely, when you are ready, it is time.
Larry Lawson tried to leave Ms. McCrary. He did not strangle her. He did not hit her. He tried to leave her. And for that, he was shot. He nearly bled out. He was criminally charged based only on her words. He was hospitalized for weeks. He was arrested on the warrants that were taken out while he was unconscious in the hospital. He's been coming to court regularly, waiting for this day. All because he wanted to leave, and Miss McCrary was not going to let him do it, except for in an ambulance. She has his blood on her hands. Compare that photo to the photos of Miss McCrary from this night, when you're back there in the jury room. You heard from the state's own witness that men are statistically less likely to report domestic violence. It's just a fact. It's not manly. But you also heard from the state's expert that 1 in 4 men are abused. Who should really be sitting at the defense side? Thankfully, the burden of proof is not on Larry, since he didn't get to have any say in what happened because he was unconscious because of Ms. McCrary shooting him. But finally today, the state has to prove it to you beyond a reasonable doubt. Oh.
Is it not advancing or just wasn't the slide you
No,
wanted?
it's just not, that's all.
No.
So I only get one chance to address you, and so I am going to talk about the law without a PowerPoint. So the first part of the first. All right, we'll talk about witness credibility then. Because you are going to hear from the judge that you determine witness credibility, and you alone. It's not for the judge, it's for you. Now, some of the stuff that you heard, particularly yesterday, that was the first time that we had ever heard it. And some of you actually may have noticed during the state's opening, we were kind of looking around looking at each other because the things that the state claimed their witnesses were going to say, we had never heard. We thought we were missing a police report. We thought we had somehow missed some evidence because what the state said in opening was so far from what was in Officer Farrell's statement, his police report, what was in Detective Dickerson's information. At no point in time had we heard that Carmen, who's mentioned in no police reports, said, oh, get off my mama. Because that is really hard to hear, right? That's very heart-wrenching. But she never told anybody that we have ever been provided notice of. That was since she's been speaking with the state. Same with somebody's gonna die tonight, or somebody gotta die sometime, or whatever the quote was. We had never heard that Mr. Lawson was accused of saying that because he didn't say it. And they never told anybody before this trial that he allegedly said it, because he didn't. So we were very much wondering what this trial was when what we had was not what the state was claiming now that their case was. And we can think of all kinds of reasons why that could be. So when you're evaluating the credibility of witnesses, one thing that one of the experts did touch on was like the movement, right? Like believe all women, the Me Too movement. Certainly, that is wonderful for society that the pendulum has swung that way. And in your daily lives, it's a great movement. But in this courtroom, it has no place in a court of law where the standard is beyond a reasonable doubt. For believe women, support women, this court is about guilt or innocence and about facts that can be proven. And staying on credibility of witnesses, no one has more motive to lie than Miss McCrary. No one. The only thing I could possibly think of that would be more of a reason for her to lie would be if she was there and she was defending herself against a murder charge. Or would she have just told her story and gotten off of that? Nobody has more of a reason to lie. The police got to her house and she had shot a man. We don't know how much time passed between that happening and her calling 911, but we know her mom was there. We know her sister was there. We know they're not stupid. You need to have something to say. And Mr. Lawson's not saying anything. But she didn't kill him. And so now he's on trial. She claimed that she didn't remember asking Mr. Lawson for money while he was in the hospital, but she didn't deny it. Now let's talk about Carmen, because Carmen was obviously a star witness for the state. But the thing about Carmen is that she was never mentioned in police reports. She didn't give statements at the time. There's nothing that she said in the past because she didn't talk to anybody. So the thing about Carmen is she's 15 years old. This is a story that's talked about within the family, certainly. The state talked to her. So what did she say? Exactly what her mom said. Exactly. And I'm not saying that they coached her or she intentionally came in here and lied. I think what happened was that was a traumatic night for everybody. She was in the bedroom, but she knows what version of this helps her mom. So her story was she saw them on the ground. Mr. Lawson was choking her. And while he was choking her, because she testified very specifically, while they were on the ground, she claims that Mr. Lawson pushed her. That's when she says the push happened. And that's not possible, but it's helpful for her mom. The other thing that she was very specific about for a 12-year-old child witnessing this, and not somebody who's just hearing a story over and over, is she said, I saw the whole thing. I ran out of the bedroom just in time to see exactly where he was standing when he was shot. And it's where my mom wants him to be. And it's between the nightstand or the TV stand and the bed. Because that is really important for Miss McCrary's story, really important. But what really makes sense? She was in the bedroom with her siblings. She didn't see anything. She didn't hear what she claimed she heard. And again, she is not coming in here intentionally trying to mislead anybody. She just doesn't remember. But the way memory works is, at the last time you thought about something, that's your last memory of it. So she's been thinking about this for over 2 years. She was very scripted. And it's because she was repeating a story that she heard and not something that she witnessed with her own eyes, that part. So as far as sympathy, I want to remind you all of 2 days ago, we were picking a jury. The state's going to try to argue, don't have any sympathy for Mr. Lawson. I didn't see a lot of sympathy for Mr. Lawson on Monday. I don't think that's where people's heads were at. And some of you were on a panel where there was a man who believed that to get to trial, somebody must have been guilty of something. When the fact of the matter is, Mr. Lawson has come to court over and over and over again because he can't come to court and say that he did this, because he didn't. Of course, it's easier to cop a plea. Innocent people do it in courtrooms like this every single day. Mr. Lawson couldn't do it. Some of you were on panels where there were potential jurors who found Mr. Lawson guilty sight unseen. They didn't know anything about the situation, and they said in front of you, I think he's guilty. Not knowing that he had been shot, not knowing anything about the situation. And that's something that we knew we were going to have to deal with. We knew that 51 people were going to come in here, see Mr. Lawson. He's a big guy, he's a strong guy, and make up their minds before we got a chance to do anything. But you guys took an oath not to do that. We'll find out together what slide is next.
They all say sympathy.
So because this is my last chance to address you, I do need to talk about the law. And I'm going to sound like a broken record because it's just so important. But the standard here is beyond a reasonable doubt, which means a doubt from which a reason can be given. There's a lot of reasons here because we're talking, but for this, I want to point out, to arrest someone, so to take out those arrest warrants, I think it's a stretch, but Detective Dickerson thought that he had probable cause to issue arrest warrants for Mr. Lawson based on what he had. This is down here to arrest someone. Now, at some point, the district attorney's office got it. Ideally, they would have done some more investigation. But here we are at trial, and there are multiple levels where you could have your child taken away. It's further down. And it doesn't take much imagination to realize why the standard is so high in criminal cases. So while we're talking about reasonable doubt and what it is, it's important to also talk about what it's not. It's a high burden, and if you and your fellow jurors are back there thinking, it's really suspicious, like why? I don't think the evidence is there. But if you're back there thinking, you know what, I think Mr. Lawson probably did what they're accusing him of doing. He probably deserved to get shot because he did what they're saying. Or maybe he did, or most likely he did what they're saying. If you're using that language, that's not guilty. And the thing about those phrasing is you don't have to fully believe not guilty. It's the state's job to prove it to you beyond a reasonable doubt. So it doesn't have to feel good. You don't have to like Mr. Lawson or dislike Ms. McCrary, your job is to determine what happened and what can be proven beyond a reasonable doubt. So the judge is going to instruct you that the state has the burden of proving each element of the crime. And you're going to have this back there with you. So you have to each individually believe beyond a reasonable doubt, even though there's no physical evidence of it, that Mr. Lawson strangled her and that he intentionally, meaning it couldn't have been a tussle where she jumped on him, but he intentionally caused swelling and a bloody lip. These are elements that you must be convinced of beyond a reasonable doubt. Visible bodily harm by hitting her in the face. And the state told you in their opening that she was struck repeatedly. She was struck in the ear, she was struck on the head, she was struck in the face. And another thing the judge is going to instruct you is you don't have to leave your common sense at the door, right? I've never been hit in the face. But your common sense tells you if Mr. Lawson punched someone in the face, we wouldn't have to be looking carefully at those pictures to see where there might be an injury. We wouldn't have to look at a picture that appears to be a screenshot of a picture that they allege is from the next day that shows her lip. A little, maybe I can't even make it out. But if Mr. Lawson punched her in the face, those pictures would show visible bodily harm. The other thing that she said was she felt ringing in her ears. Another thing that we can't see. She doesn't have an injured ear. We don't have any pictures of an injured ear or any bruising on her head or face. And apparently she's capable of taking pictures of herself and sending them to the South Fulton Police Department. So if she did have any swelling or anything the next day, you best believe she would have taken a picture of it and sent it to them because she managed to do it with her lip. But you have to hold the state to these elements, including intent. And you heard all about what strangulation is and what it isn't. And the testimony was far from conclusive about what actually happened in that living room, but it was not strangulation. So the judge is going to instruct you that you have to reach a unanimous verdict, right? So you all have to agree, but you don't have to agree on why. You have to agree on your verdict. But you each may have different reasons today. And you're gonna come up, you hopefully have more than I'm gonna list off because I don't have unlimited time. But let's talk about some reasons to doubt. First, the lack of investigation. You should be pretty frustrated that in a shooting case, there was no investigation essentially. So Detective Dickerson, who should be ashamed of himself, and honestly, when he was sitting there, when his testimony was over, he bolted out the door so fast that the chair spun. I don't know if any of you guys saw that, but he bolted after his testimony that was frankly shameful. Didn't test any substances, didn't send anything off to be tested, didn't get Mr. Lawson's medical records to realize that the bullet was removed from his leg surgically, which he told you when he testified. He didn't test any suspected blood. He listened to Miss McCrary, and then he told his crime scene investigator where to look for evidence. He's the one. He tried to pass the buck and say, oh, well, the crime scene tech would have taken pictures of her face. The crime scene tech was like, well, the detective tells me what to take pictures of. So he was trying to pass the buck, but it was up to him. And what he told her was this shooting took place in the bedroom. So where'd she find one shell casing and one bullet? In the bedroom. Mr. Lawson was shot in the hallway. which you will see when you look at the pictures, the amount of blood in the hallway. We don't have a shell casing from the hallway because they didn't look for one. And she tried to waffle, oh, yeah, we looked all over the, well, they didn't find the gun box either. That she says was, Ms. McCrary says was there. So I don't think they looked through the whole apartment. They had their theory and they collected evidence to support it, despite the massive amount of blood that Mr. Lawson lost in the hallway leading towards the kitchen. It's a lot more convenient for the state. There's no evidence. There's a lack of evidence on many levels, but one thing that Mr. McCrary harped on was, I closed the door and locked it, and he picks the lock and picked it with what? This is a crime scene. You can't find like what was damaged to the door, how it was broken, because it wasn't. That door wasn't even closed, and he wasn't even in the room. Let's also talk about reasons to doubt witnesses who didn't witness anything. If you think about it, the only person who really witnessed anything is Ms. McCrary. And then Ms. McCrary told other people who then came in and told you guys what she told them. So just because the story is repeated over and over through different people does not make it true. It just makes it repetitive. She told her mom, she told her sister, she told her other sister. Those aren't witnesses. Those are people she told things to. Oh, I don't even know if I want to waste your time with a strangulation expert. She was clearly hired to come up here and tell you to ignore the evidence that this 200-pound man strangling Miss McCrary wouldn't leave marks. Do with that what you will. But that's all she came up here to say. Is don't worry about the lack of any scratches, bruises, anything on her, even though she was violently attacked. She was hired to do that, and that's what she did. Rosa James, again, just like the strangulation expert, never met Mr. Lawson, never met Ms. McCrary. Certainly wasn't there that night to give you any details about what happened. Very generic testimony. She was great. I'm sure she's a lovely person. She just doesn't add anything in this case in terms of actual evidence. She talked about the movement some. Again, there's no place for that when you're talking about a felony jury trial. And she actually told you that she is trained to believe accusers. She worked for the district attorney's office as a victim advocate, and you've seen victim advocates throughout this coming in now. They're all trained to believe accusers. She also told you that someone with a disability is more susceptible to being abused. And that when a gun is involved, the increase in fatality risk rises 500%, was what she told you. Who introduced the firearm into this situation? It was not Mr. Lawson. Mr. Lawson didn't even want her to get that gun. He could see where this was headed with their history. Ms. James also talked about an abuser isolating their alleged victim, right? There is not only no evidence that Mr. Lawson tried to alienate Ms. McCrary from her support system, there's ample evidence that Ms. McCrary's support system runs deep. Her mom and her sister live 4 to 5 minutes away. Her other sister lives 15 minutes away. She sees these people all the time. She is not a domestic violence victim. She does not fit any of the things that Ms. James talked about. She's not someone who was cut off from her loved ones. The state tried to make it seem like Mr. Lawson paying her car note was somehow controlling her. But you heard Mr. Lawson say he paid the car note and she let him use the car when she felt like it. She controlled the car. So it's actually sounding more like she exerted more control. Now, when Ms. Hopper was called, this was another inconsistency. She was called, best I could tell, just to corroborate that Ms. McCrary had a sore throat that night. And so the state got her to say, I got her some water when she was in the patrol car. And I guess wanting us to think that that was somehow evidence that she somehow had a sore raspy throat. But Ms. Hopper, when asked, testified only that what Ms. McCrary asked for was water because her mouth was dry. She didn't even mention anything about a sore throat. She asked her sister for water because her throat was dry. The number one reason to ask for water, because you're thirsty. Now, I don't even know if we need to get into why Ms. McCrary lied. She told you why. She showed you why. She didn't want to go to jail. She very successfully manipulated Detective Dickerson into not arresting her and into the district attorney's office, bringing this thing all the way to trial. So you all heard what she told Officer Farrell. Officer Farrell, just doing his job as the first responding officer, but there wasn't any evidence for him to collect. And we're not saying he did a bad job. There weren't injuries for him to photograph. There weren't injuries for the crime scene technician to photograph. They're really trying to tug at your heartstrings with this child thing because it is obviously, we're all sympathetic. We all have children in our lives. This is a tactic. They want you to think that Mr. Lawson is a monster. That's what this whole trial has been. They want you to believe he was a monster who deserved to get shot. Don't worry about it. So I get that Ms. McCrary claims that she couldn't possibly give accurate statements the night of because she was so worried about her children, even though her mom and her sister were with her children. Her mom testified to being in the room with, but she just didn't have the full story straight. She had enough to not get herself arrested, but she didn't have her full story straight. Officer Farrell. Nobody followed up, including the detective. We have no actual evidence other than Ms. McCrary's testimony about alleged alcohol consumption. And we also don't know what Ms. McCrary's BAC was, blood alcohol content. So let's talk about the CSI witness. We already touched on it. Horrible investigation, no testing of anything. She recovered the shell casings and the one bullet, or actually I don't even think she recovered the defect, but it wasn't the bullet that hit Mr. McCrary as it was taken out of his leg. And she's probably great at her job, but she's led by the detective. So she did what the detective told her to. Detective Dickerson already had his theory. And so she was a foot soldier. She collected evidence to support his theory. That was likely the first shot. Doesn't really matter what in which order the shots were fired, but one of them ended up in Mr. Lawson's leg. All the new information that we already talked about, all the information that Detective Dickerson did put in his report. To take out warrants is one thing, probable cause. But to not even, I mean, Mr. Lawson had a right as a criminal defendant not to talk to the detective, but as you can see, wild horses couldn't have him off the stand. And if he had been given the opportunity before his arrest to tell the detective or anybody in law enforcement what happened, he would have. So again, the only time police were called was after she shot the victim. And this other, so when you're in a situation where you're accused of something like this, the state is allowed to bring out other bad things that you did in the past to make you seem bad. And that's what the state did here. He called her names. We deny that, but also why are they telling you that? Because they.
Your Honor, I'm going to object to this because the state did not bring that out to make him seem bad. That was not the pretrial ruling in which Your Honor allowed us to bring it out.
Okay, you're gonna get to argue the import and impact of that evidence in the same way that Ms. Feely is right now. You'll argue it differently, but you'll have the same opportunity.
So why would I bring up that he called her names and that there was this other incident? It's because they lack evidence in this case. If they had enough evidence that Mr. Lawson did what they claimed, they would rest on their evidence. They wouldn't just try to make him seem like a monster. And the same with the strangulation expert and the DV expert. They are padding this case so that you will overlook the fact that there is one witness who witnessed anything, and she has the most motive to lie of any witness that I can think of. The state's theory that he was shot in the room really is a stretch when you start looking at how he was bleeding. They were coming in and out of the room once he's on the ground bleeding out. Was it blood? What was it? It was not blood from him bleeding out because he was shot in the hallway and that's where the majority of the blood is. And I think you saw where he was shot. He was shot. He's not moving around after getting shot right in the kneecap, going back to his artery. You can see how much more exaggerated the story got from talking to Officer Farrell. And even on the 911 call, she knows she needs to come up with something. So, and then talking to the detective, and then the evidence that was on the body cam of, I have a bloody lip, and the officer saying, oh yeah, I see. You saw it? Then why didn't you take a picture of it? We didn't see it on the body cam. Okay. Yeah, not hard on this. The physical evidence just doesn't support being punched in the face or being bloody. It just doesn't. And once you find the lie, this is the woman who just shot somebody. Compare this to the blood in the hallway and use your common sense. You heard from Ms. James that the most dangerous time for a domestic violence victim is when they try to leave. He left all right. He's lucky to be alive. And I'm not saying that you have to not like Ms. McCrary. to know that her testimony was what she needed it to be. Because for one thing, lying to the police is a crime too. So once you got your story out there, you gotta stick to it. You can exaggerate it more, but you can't come clean about, actually, that's not how it happened. He didn't attack me. I didn't want him to leave, so he didn't leave. But that doesn't change the fact that she shot an unarmed man and it went scot-free. Not only did she go scot-free, he, Mr. Lawson, who has already suffered enough, is on trial for the picture that you saw of her with no injuries on. I can't think of a reason why you would not let someone leave if you're scared of them. She blocked the door. She didn't want him to leave. But she was scared of him. One more witness, didn't witness anything, didn't witness any bruising or redness. No breathing issues. Didn't ask to be checked out. So that little puddle on the carpet, because carpet can soak in some blood, or why did she lie about where he was shot? Why is she lying about all of it? The same reason. The judge is going to instruct you that a conviction is only authorized if the evidence excludes all reasonable theories of innocence and proves Mr. Lawson's guilt beyond reasonable doubt. We are so far below that. Sorry. So all of Ms. McCrary's witnesses are related to her, that she brought that actually were not hired by the state. They were together for 4 years. But they know their loved one just shot an unarmed man. They too have common sense and knowledge. So, Mr. Lawson has no burden here. The state had to prove his guilt beyond a reasonable doubt. Like I said before, he could not have been stopped by an army from testifying. It's his right to testify. He wanted to finally have someone here. He told you that he broke up with her essentially via text. She confirmed that she received that text that day. That's one thing we all agree on. He was trying to leave her. She got the text message. We talked about Miss James and Miss Williams and what they didn't really add to this case. The judge is going to instruct you that you are not to concern yourselves with sentence, with punishment, right? Your job is merely guilt or innocence. Did you have the indictment? If you're going to have the indictment back there with you. Count 1, aggravated assault, a felony. Count 2, battery, visible bodily injury, a misdemeanor. So if you make Mr. Lawson a convicted felon, you have no say in how much punishment he gets or the collateral effects of a felony conviction. There will be punishment.
Objection, Your Honor.
Let's
Objection.
move away from punishment, not anything the jury needs to dwell on.
to be clear, the witnesses in this case are either biased or add no value. This is exactly how wrongful convictions happen with this kind of evidence. And I've got to tell you, as Mr. Lawson's attorney, I'm scared. My PowerPoint's not working. Criminal justice system has gotten Mr. Lawson's case wrong every step of the way. Letting Ms. McCrary lie and get out of being charged herself. By charging Larry on nothing but Ms. McCrary's self-serving statements. And then the DA's office, Fulton County District Attorney's Office got this case and prosecuted it to the fullest extent. Every resource on this case, because he dared assert his factual innocence. They brought him to trial. To make it to trial, particularly in a county like this, you gotta really want it. That's where we are. This system is meant to break you. And you don't have to love Mr. Lawson to see that he's not guilty. He gets animated when he talks. He's got his manner of speaking because of his injury. You might have seen him, I saw a couple of you look over at him when the 911 call was played. He was crying quietly as he could. And maybe you have found that in a way, I don't know. But he was listening to when he was dying in that 911 call. And he got overcome a little bit with his emotions. Now the state, when they were yelling at Mr. Lawson, accused him of having all this time to concoct a story. He would have told that story had he been conscious that night. He would have told the exact same thing. Just because he didn't have a chance, and so much time has passed, not because he didn't want to come to court. Sure, he had all this time, but it wasn't to concoct the story, it was to tell the truth. You know who had time to concoct the story is the McCrary family. Because when your loved one just shot an unarmed man, you all need to get on the same page. And then they had almost 3 years to make sure. They spoke with the victim advocate, they did with the DA's office. He had the same truth the whole time, just no one asked. Right. So the state gets to come up here and just try to make you overlook what the evidence was and what it wasn't. And since I don't get to come up here again, I want to go over a few things that are gimmicks that the state often uses. One is they might show you a picture of a dollar bill that's like a puzzle pieces. And some of the puzzle pieces are missing. And the state sometimes argues, but you can tell us a dollar bill. You don't need the whole story, right? You can tell us a dollar bill. If they use that, just keep in mind, you can't tell if it's counterfeit. And if somebody's facing the gravity of the situation here, wouldn't you want some more pieces to the puzzle? Wouldn't you want to know if that dollar bill was fake? And plus, this isn't a gimmick. This is Mr. Lawson's life. Now, the other one that they often use is the gas station. So you go to the gas pump, you put gas in your car, you crank your car up, and now your car's full of gas. You didn't see the gas go in, but you know it did. Circumstantial evidence. That's not what we have here. And just because you put gas in the car, if it doesn't have wheels on it, it's still not going to run. So they use all these lighthearted things to try to convince you whatever. This doesn't have anything to do with dollar bills or gas stations. You'll have the indictment back there with you. The judge is going to instruct you. After giving consideration to everything you've heard and seen in this case that was presented in court, if your minds are wavering, unsettled, or unsatisfied, which they should be, it's your duty to let them. You don't have to necessarily feel great about it. You have to do it. If your minds are wavering, unsettled, or unsatisfied, if you're back there wishing there had been an interior camera so we could see what actually happened, that is reasonable doubt. If you're back there wishing that there was some more evidence of what happened in the living room, or where the keys were, or if there was another bullet shell casing somewhere, or if we could have had more evidence of another eyewitness. If you are back there discussing what you wish you had, that is reasonable doubt. If we had a video in this case, we wouldn't be here. And if you are wishing that we did have more evidence, you have got to find Mr. Lawson not guilty. So we are, as a defense, asking you to remember the bigger picture here. Ms. McCrary shot an unarmed man in the home they shared. Ms. McCrary came up with a self-serving statement that was unchallenged until today, till this trial. And that's the whole state's case of an aggravated assault, strangulation, and a battery with visible injury. Battery with visible injury with no pictures of an injury, and aggravated assault, strangulation with no evidence of strangulation. So we are asking on behalf of Mr. Lawson that you return with the only verdict that serves the interests of justice. And that is finding Mr. Lawson not guilty of these offenses. Sorry again for the PowerPoint. Thank you.
Thank you, Ms. Feely. All right, if you guys want to just stretch about a little bit, I'm going to turn to the state. If you'd unshare the screen, please. Okay. All right, we're actually going to take a quick break. So do more than stretching. I'm going to try to keep it to only 5 minutes, especially since you have a second restroom working out, but we need to do that. So we'll try to get you back here at 2:25 on that clock, assuming you guys are ready to do that. And we'll have the state's PowerPoint in theory ready to go. Don't talk about the case.
We will share it with them. I'm gonna do this.
So two things, Ms. Beza, if you'd stick around for one quick sec before we start the break. One, I'm going to give to Ms. Rivers over the break all 65 note cards that were questions from this inquisitive jury. And I'm going to ask the lawyers during the time I charge the jury, if you could quietly enough go through the evidence to see if there is any disagreement about what goes back with the jury. I don't think there should be, other than demonstratives. The state may say they should go out. We can have that discussion. But other than that, everything's in. And I'll let the jury know we've got a way for them to listen to audio and watch video if they want to do that using equipment that is in the jury room. Ms. Beza, anything before we take a quick break? Ms. Feely. Okay, thank you.
Exhibits in order by number. Yeah, you can go.
Ms. Rivers here. Yeah.
My lip, as you can, I'm not sure if you can see. I can see the blood still in your mouth. He punched me, and I was telling him to back up, get away. He bust my lip, as you can, I'm not sure if you can see. I can see the blood still in your mouth. He punched me, and I was telling him to back up, get away. He was trying to abuse me in front of my kids. I shot him in the leg. He passed out. Okay, what's the address? He was trying to abuse me in front of my kids. I shot him in the leg. He passed out. Okay, what's the address?
South Florida PD.
663 569, sir. He's right here.
Sir, please.
221 radio.
Sir,
Yes,
Go
ma'am.
ahead. I'll have fire and four come in.
5169.
officer.
Who shot him? You? Okay, come with me.
Yes, he was.
It's okay.
He pushed my child.
It's okay. Come on this way. I'm going. Wait, let me grab you by your arm, okay?
Yeah, you got
South Florida PD.
663 569, sir. He's right here.
Sir, please.
221 radio.
Sir,
Yes,
Go
ma'am.
ahead. I'll have fire and four come in.
5169.
officer.
Who shot him? You? Okay, come with me.
Yes, he was.
It's okay.
He pushed my child.
It's okay. Come on this way. I'm going. Wait, let me grab you by your arm, okay?
Yeah, you got
Look, investigator's gonna talk to you and everything, okay? He came home drunk? Oh, man.
I told him he tried to leave out the home for some reason, and I was like, "Why are you going? You had something to drink." So I attempted to take the keys from him, my car keys,
Okay.
and he told me to give him the house keys. So I was like, "Okay," but then he would not give me the house. He would not give me the car keys. So I stood in front of the door, and I told him, "You're not gonna leave because that risking somebody dying." You killing yourself. It's innocent lives out here.
Definitely understand.
And all I wanted was the keys and for him to lay down and go to sleep to sober up. And
Is he, like, are y'all married or anything?
no, it's my son's father and my 2-year-old.
Look, investigator's gonna talk to you and everything, okay? He came home drunk? Oh, man.
I told him he tried to leave out the home for some reason, and I was like, "Why are you going? You had something to drink." So I attempted to take the keys from him, the car keys,
Okay.
and he told me to give him the house keys. So I was like, "Okay," but then he would not give me the house. He would not give me the car keys. So I stood in front of the door, and I told him, "You're not gonna leave because that risking somebody dying. You killing yourself. It's innocent lives out here."
Definitely understand.
And all I wanted was the keys and for him to lay down and go to sleep to sober up. And
Is he, like, are y'all married or anything?
no, it's my son's father and my 2-year-old.
Look, investigator's gonna talk to you.
Latanya gave her water, and Heather Williams testified that forearm on neck is strangulation, anything to block the airways. And she further testified that strangulation victims do have dry mouth. You would have to find that Carmen was just completely making this up to find him not guilty of strangulation. Battery family violence. Person committed a battery against a person with whom the defendant has a child. Well, in regards to the second element, they have a child together. He testified, she testified, Aiden. Aiden is their child. He was 2 at the time. And battery occurs when a person intentionally causes substantial physical harm or visible bodily injury to another. Visible means the bodily harm is capable of being perceived by another person. There are multiple witnesses that testified, and you saw State's Exhibit 11. You guys are people, another person that sees the injuries, the injury to her lip. Officer Farrell in the body camera, yeah, I see it. You have the picture, State's Exhibit 11. The EMT worker, she didn't take pictures, she was an EMT worker, but she documented in her report the visible injury. Therefore, he's also guilty of battery. He committed a battery. He repeatedly punched her and hit her in the lip and ear, side of head really, which is why she had a vein to her ear, and caused the busted lip, swelling to her face. EMT report, injuries. Lieutenant Dickerson report, injuries. Body camera, Officer Farrell said injuries. You can kind of see it when she does this and pulls out her lip when she's in the car. And Exhibit 11, injuries. And again, they share a child together. Therefore, he is guilty of battery family violence. I want you to look at the entirety of the case, the entirety of events, the entirety of the evidence. I want you to look at the history between them. Listen to the 911 calls. Rewatch the body camera. Remember Kanice's demeanor on the stand, Carmen's demeanor, her sisters. Her sisters didn't fabricate. They didn't say, oh, I came there when he was on top of her. They didn't say that. They're like, no, we came after. Look at the entire picture. And I ask that to return a verdict of guilty for both counts. Not only aggravated assault, but also battery family violence for him busting her lip. Thank you.
Thank you, Ms. Beza.
Oh, seriously.
So next up is the jury charge, where I read a pages is this 9-page double-spaced document to you all. I'm ready to do it now. Does anyone need a break before that? You good? Okay. A few things about it. Do one more thing. It being the jury charge. Should be on the screen now. Voila. And Ms. Beza, I know you just sat down, but if you would come grab this, one copy for the state and one for the defense. All right, I am about to share with you the law that you must, not may, but must apply to the evidence as you find it to be. I'll be reading from this document. As I read, the things I'm reading will be up on the screen for those of you who benefit from seeing the words that are being spoken. You will also get this document during your deliberation. So there is a little bit of legalese in here. I do my best to make the language accessible, but there are certain concepts that higher courts have said, here's how you have to define X, whatever it is. So I apologize for any stilted language that you may get, but worry not, you'll have this document to pour over should you need to. So you're welcome to take notes, but if I blow through something and you're still trying to figure out which preposition applies to what, you'll have this document with you. With that, let's go. A grand jury has indicted the defendant for aggravated assault and battery. They did so in this indictment, which you will also have with you during your deliberations. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or both of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and each element of each crime. And I'll give you those elements in a little bit. There is no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is instead a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all that evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crimes charged or merely raises speculation about his guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law, which is what we're doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence that was presented. You must then apply the law that I gave you to the facts that you find. You must decide the case based only on the evidence presented during trial. That evidence consists of testimony and exhibits. Evidence does not include the indictment or plea of not guilty, anything I've said, or anything the lawyers have said to include their opening and closing remarks, nor does it include any question that was posed. Now, the evidence that you did receive may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw the blue car hit the red car. I was right there. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. An example would be if four people in a row walk in this courtroom and they have umbrellas that they're shaking off and jackets that are wet and they're wet, that would be circumstantial evidence that it's raining outside. You can't see it because we have no windows in here, but that type of evidence might for you be circumstantial proof that outside it's raining. There's no legal difference in the weight that you may give to direct or circumstantial evidence. And in considering the evidence, you are free to use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses. In deciding this, you're free to consider the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of this case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between what a witness said before trial and here in court. You've heard from expert witnesses. These are people who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon their training and experience. Testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. Evidence of prior difficulties between the defendant and the alleged victim has been admitted solely for the purpose of illustrating, if it does, the nature of the relationship between the defendant and the alleged victim. You are not to consider any prior difficulties evidence for any other purpose. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. It must be proven by the state beyond a reasonable doubt. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from your consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the two alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. All right, to the elements of the two alleged crimes. We start with aggravated assault. For aggravated assault, the state must prove that the defendant, number one, assaulted another person, two, with anything that, when used offensively, is likely to or does result in strangulation. And a person commits an assault when he commits or attempts to commit a violent injury to another. And under the law, strangulation means blocking or interfering with another person's normal breathing or blood circulation by either applying pressure to the person's throat or neck or obstructing the person's nose or mouth. Family violence battery. For family violence battery, the state must prove that the defendant, one, committed a battery, two, against a person with whom the defendant has a child. Battery occurs when a person intentionally causes substantial physical harm or visible bodily harm to another. And this term visible bodily harm means bodily harm capable of being perceived by a person other than the victim. It may include, but is not limited to, substantially blackened eyes, substantially swollen lips, or other facial or body parts, or substantial bruises to facial or body parts. Voluntary intoxication is not a defense to a crime. If the defendant, when sober, could reason and distinguish between right and wrong, and he voluntarily becomes intoxicated and then commits a crime while intoxicated, he is responsible for that crime just as if he had been sober at the time he committed the crime. You all should consider each count in this case individually. The defendant may be found guilty of one, both, or none of the charges. If after considering the evidence, together with this charge, you should unanimously, all of you, find beyond a reasonable doubt that the defendant did commit here in Fulton County one or both of the crimes charged in this indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty, and you would check that option on the verdict form you're going to have. It's going to say guilty, not guilty. If you reach a verdict, you pick whichever your verdict is, guilty or not guilty. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we the jury find the defendant not guilty, and you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous, and your verdict must also be in writing, and you're going to get a verdict form, signed by your foreperson and dated. By no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence, according to the laws given to you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based on improper considerations of race, gender, religion, or sexual orientation. Ladies and gentlemen, you are the fact finders in this case. You are not to concern yourself with punishment. That is a role for me. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. Same rule we've been dealing with throughout the trial. You have all the evidence in this case, and it would be improper to supplement it with any outside information. To assist you in complying with this important instruction, Deputy Gordon will be collecting all of your electronic devices, to include smartwatches, while you deliberate. When you're done deliberating, I promise you get them back. If you don't finish today and come home because you need to come back tomorrow, we'll give them back to you today. But while you are behind that closed door, privately deliberating amongst your number, no devices back there, with one exception I'm going to tell you about in a minute, but it doesn't belong to you. From here on out, if you need to communicate with me for any purpose, question, concern, I want my phone back, it needs to be in writing. Upon receipt of your question or note, I will confer with the lawyers and share with you whatever response I am allowed by law to give. And that last little bit's important. You may have a great question, and the answer may be, you have to figure that one out, because legally I can't answer it for you. Don't think I'm being difficult. I'm trying to try this case one time and not two times. And so I ought not to give you an instruction that the law doesn't allow me to give you. And as I told you at the outset, my answer to your question of, hey, could we have a transcript of witness X's testimony is going to be, nope. You have to recall what that witness said. Now, the kind of exception to that, and it relates to the piece of electronic equipment you have back there, you may have noticed there's a big screen on the wall. That has a little computer stuck to the back, and we can load onto that computer all of the digital media. You've heard 911 calls, there's been some body cam footage. If you want to review that, you need to let Deputy Gordon know, and we'll get that onto that computer, and you can review it and discuss it as you're reviewing it. In the olden days, you had to come out here and we'd play it, and you couldn't talk about it in front of us because you can't deliberate in front of us. And you might want to rewind and see this one thing. But in this jury room, there is now a way for you to review the audio and video evidence within the privacy and confines of the jury room. So that can be a question you ask us. I'm going to try to consolidate all that digital evidence onto one thumb drive so we can get it loaded onto that little computer. So that concludes my instructions to you. I need to do one more thing, and that is to say 12 of you are, 14 of you are going back to jury room, but 2 of the 12 of you can actually keep your electronic devices, and you need to get whatever you've got in the jury room, and Deputy Gordon is going to take you to our auxiliary jury room that says shelter location on it, where you will wait as the alternates in this case. And that would be Mr. Niemeyer and Ms. Herron. You are alternates. If we have to excuse someone, one of you will join the deliberating jurors. They'll reset and you will be a part of those deliberations. But I am going to have you stay here today because you never know when we need to excuse a juror. So if the 14 of you will go back to the jury room, and then the 2 of you that I mentioned, get your stuff and go with Deputy Gordon in the other space. Please don't start your deliberations until you get the physical evidence. You're going to get that, the jury charge as promised, the indictment, and the verdict form. Okay, thank you.
All right, for the jury.
Did I organize them there? And we took out the 3. We kept them. So we'll see if they're gonna object.
Oh, you were?
I was.
Oh, that's.
The only thing that's out of order is the gun.
Which one is it?
Some kind of t-shirt. He looks.
I need to do a verdict form, which I'm going to do and circulate with you all. You can be at ease right here.
Yeah, Ms. Rios, are you gonna object to the 2 demonstratives of the living room and dining room being sent back? We took these out, clearly.
Yeah. At ease, meeting Mr. Lawson, go to the restroom, just right here.
Sure.
I know, but you only come for this trial and you're seeing more. Oh, yeah, like this and that, like I supervise the unit, so. Oh, supervise. So like, I think I'm getting Lance, who's new, or do you know Kenny? Yes, okay. Or her, she used to be, so.
She used to be in here. That'd be a homecoming. for her.
Yeah, oh, she definitely might be back instead of Lance now that we're losing another person, so.
Oh, who else is going?
Well, Shaniqua Christian is gonna be moving into her new position March 3rd.
Oh,
And
she's
so
staying
her
at DA's office.
Yeah, but her courtrooms have to redo courtrooms again.
Yeah.
You guys didn't leave anything in there, did you?
Oh, no, but Mr. Lawson is being much.
Oh, let Deputy Gordon know.
That's where I thought I saw him.
Okay, sorry.
So say right here.
Yeah. We don't have.
Hold on, I'm gonna try to print out the verdict form, I'm not sure. Why it's not going. Good. Boy. Back in. So we need the jury charge, we need the indictment,
It's a CE, right?
Yeah, that goes to.
Yeah.
What's that?
You were wrong. Yeah, they probably won't.
I'm waiting on this body camera.
Like, let me think, just. Did they write the numbers down to? They write the numbers and stuff?
Oh, yeah, I need a phone number, one number for each side to call in case you aren't in court, if there's a question. Or verdict or whatever.
You know, like, when you open, oh, just like.
Thank you.
Trying to get the body. Because I don't have to like. If you don't try that at home and try work on this at home, I need the body camera. I need to. What if there's a way? So this is the full out. What if there's a way I can just think I will. Copy, right? I don't even think there's other word. Let's say that that's not me. Let's just see. No. Fun.
Just waiting on the verdict form. You want to print here, so someone's bringing it in.
Say media ass.
Yeah, let's see that. That works. We should say that here. Okay, yeah. Yes.
Say media and stuff.
Hey, man, I don't know why it won't print here. Print something else out. Thank you. Ms. Rios, we come, well, Deputy Gordon will give it to you. Look over the verdict form and then have the state give it a look. All right, let's get one more thing on the record. Ms. Beza, before we take this back to the jury, this being the evidence, did you confer with your counterparts on Mr. Lawson's side about whether there's any dispute about what should go back with the jury?
I did, Your Honor.
Any disagreements?
No, Your Honor.
Okay, and did you look at the verdict form?
Yes, Your Honor.
Any issues with that?
No, Your Honor.
Ms. Rios, same two questions. You okay with what's been designated as going back with the jury?
So we did have a question about the new, I think it's new, at least for me. They have the capability of playing audio and video back there.
Yes, ma'am.
And do we get to know what they're listening to?
So can we send this back? We'll talk about that, but
Sure.
we're gonna send back. They can't play anything right now.
Or
All right, thank you, Deputy.
Just want to make sure that last CD.
It did. We popped it in there. So let me describe the situation and then I'll address any concerns you might have. There is a flat panel TV about this size mounted on the wall. Behind it, you can't really see it. There's a little computer stuck to it that has nothing on it other than Windows. It's not connected to the internet, so you can't surf or browse. When you log in, as the way we'd log in, what I have done in previous trials is I get a thumb drive, usually it's from the state, and they've put on it all the exhibits that are digital media. It could be audio. It probably wouldn't be the pictures because they have hard copies, but it could be the pictures. But it's usually audio and video, body cam, et cetera. And those files are numbered. So it would say Exhibit 15 if that was Farrell's body cam. That's all loaded into that computer. I take away the thumb drive and they have a keyboard so that they can control the computer and that way they can play the files. There's a media player on that. There's not a web browser or anything like that. And that if they want to watch the body cam, they can watch it and they don't need to come out here because that's not required. That's a piece of evidence. And just like they could stare at a still photo of the front door of apartment C7 all day long, they could listen to the 911 call again and again. That's the setup.
I just have concerns for instance, Officer Farrell's body cam, we only played 7 minutes, so they only have the 6 minutes, 50 seconds, or however much was played.
So I don't know what was admitted. I agree that we played a segment of it, but there was no objection to the admission of the entire body cam. If we need to get the state to come up with an edited version, and by edit, I mean only they snip off the tail end, however long that might be, I'm fine requiring that. But I'll note there was not an objection made to the whole body cam coming in. I'm not playing cutesy. It may be that everyone had agreed. The only part that would ever be played is from 0 to 7 minutes. If that's the case, then we need to get an edited version from the state that stops at the 7-minute mark so that they don't keep it playing. And then there's all this discussion about, oh, Larry Lawson's a bad guy, whatever someone may have said on there that the jury didn't hear. I assume they stopped playing because that's all they wanted the jury to hear and not that there were objectionable parts after it. But we can navigate this in whatever way you all, if you can agree, whatever you agree to.
I think we probably can because I didn't realize that if the whole thing was admitted, it would go back to them. I thought just what was played, we were limited, and we had talked beforehand and agreed
Okay.
what portions to play.
Well, why don't we do this then? Again, they can play nothing right now. Before anyone decides to leave the courtroom, the lawyers, why don't you make a list of the digital evidence? And then if there's anything that needs to be edited by cutting off a part of it, then let's see if the state can do that. If not, then they'll have to come out here to watch it because I'm not going to say, don't play it past minute 7. No one's policing that. And I will have given them bad advice and I'll explain why. But it would be great if we could just have it so they don't need to bother us and we don't need to be watching them while they process it.
And I'm gonna go through and just double check, but that's the only one that comes to mind, and to not make more work on the state, maybe we could just remove that one while we figure out if it's easy to edit.
We can easily trim it.
Okay.
We're doing it now, actually.
Good. Look at this. Crutchfield, the video editor. So talk amongst yourselves about what the exhibits are and if anything needs to be edited. I'm happy to come up with a thumb drive if the state doesn't have one, but you'll get your thumb drive back. If you could consolidate all of the digital exhibits onto one thumb drive and then just partner with the defense to see if everyone agrees. And then you may be renaming the exhibits and that's okay with me, but the exhibit should just say exhibit 16, body cam, exhibit for whatever the descriptions are on the exhibit list. Okay.
Yes, Your Honor.
Thank you. Are they good? Okay. So I'm going to mute the system here and we'll be on break until you all have me come back if we need to navigate something about these video and audio exhibits or when there's a question from the jury.
You want to see
That's fuzzy.
That's me, sorry.
Okay. I'll get, Ms. here in a second to get a few things on the record. They thumb drive, if you sort that out, or do we need to get things on the record about a dispute?
We sorted it out, we cut the video, showed it to Ms. Rios. There are 4 things on the thumb drive.
Okay.
911s and body cam.
3 911s and body cam. Okay.
I think we are gonna make, just because this is new to my office, but we still continue with witness objection when Mr. Hurd is back out.
That's fine.
Especially in this particular case where there's nothing from us and a bunch from the state.
Okay. I'm trying to think if, I've actually, this will probably be the 4th trial I've had since that equipment went in, but it must not have been a PD trial. When you say it's new to the office, I mean, it clearly wasn't you two. I don't think it was Ms. Wood, so it may have been other things. All right, well, let's get on the record. You ready?
Yes.
Okay, I have 2 questions from the jury. We're back in court on State versus Lawson. The first they're not numbered. The first one I'm going to read to you. Is Mr. Lawson left or right-handed? The second is, can we get the thumb drive to see the body cam, comma, et cetera? Let's start with the second. Ms. Beza has informed me that she's got a thumb drive that has 4, I'm gonna call them all digital files, 4 files, the 3 911 calls, which is the hang up, the follow up, then I think Ms. McCrary's mother, but it's the 3 phone calls. And those are on there in their entirety, and there's no objection to those being available in their entirety, apart from the continuing witness objection that we'll hear in a minute. Is that correct, Ms. Feely?
Yes.
The 4th file is Officer Farrell's body cam, and the state has agreed to, and I think has done for what's on the thumb drive, to end the recording at the same point that we ended for what was played at trial. So apparently the body cam extends further. That additional footage will not be available for the jurors to review in the privacy of the jury room. Is that a correct technical description?
Yes, Your
Ms.
Honor.
Beza? Okay. And Ms. Feely, you don't object to the truncation. In fact, you asked for it. But you do want to get something on the record about this concept of empowering jurors to look at evidence without you looking at them. Okay, what's that objection?
So we are objecting based on continuing witness, and I think it's particularly unfair in this case. And as Mr. Lawson has been adamant in my ear about, well, if they get those, why don't they get the police reports with inconsistent statements? So they can play over and over and over again the statements that are very helpful for the state, and they only got to hear me once lay out the inconsistencies in all the statements.
Okay, I understand his perspective. I don't think this involves continuing witness. It's not the testimony of a witness, but it is a piece of physical evidence that's been admitted in the same way they could look over and over and over again at the blood in the bedroom and think about how that doesn't line up with things that Mr. Lawson said. But they could think that it's wine in the bedroom, and they will work through that. If you get that thumb drive to Deputy Gordon, we'll work through getting it on the computer in there. But your objection is noted, and it's a continuing objection. You don't need to remake it. You're not going to know if they watch it once or twice. The other question is Mr. Lawson left or right-handed? They have to rely on their collective recollection of what's in the evidence, unless both sides don't mind getting in front of them, whatever the answer is. Let me start with the state. Ms. Beza, any thoughts about what I should write on the back of that card?
The evidence is closed, and therefore you should rely on your own recollection as to the evidence, as Your Honor just stated.
Okay.
The state will not be agreeing to say he's right or left-handed, as that could change at any moment.
Meaning he could suddenly become left-handed?
Correct. He can say I'm left-handed, I'm right-handed, maybe he's ambidextrous, I don't know.
Okay, all right. Ms. Rios or Ms. Feely, thoughts about how to answer the handedness of Mr. Lawson?
We agree with the state on that.
Okay, let me write something on both these, tell you what I've been writing, and we'll seal the deal. All right, I labeled as question 1, is Mr. Lawson left or right-handed? On the back, I wrote, you will have to rely on your collective recall to determine if that was introduced as evidence. And question 2, can we get the thumb drive? I wrote yes on the back. Ms. Beza, any issue with either of those answers?
No, Your Honor.
Ms. Feely? Okay, you've got the thumb drive. Do you remember how to work it? You know, like the password and everything? Oh, dude, all right.
Thanks, Ms. Hands, Peter.
Okay, all right. Deputy and IT guy. We shall return to our break. Ms. Beza, anything else before we do that?
No, Your Honor.
Okay, Ms. Rios.
No, Your Honor.
All right. And they have asked to come back tomorrow. So I'm going to bring them out in a minute, ask them when they want to come back tomorrow, not meaning noon, but 9 versus 9:30. I'm open to that. Ms. Beza, anything we need to discuss before I bring the jurors out?
No, Your Honor.
Okay, Ms. Rios?
No, Your Honor.
Okay, let's bring them out, and our alternates still in there? If we could get the alternates also, please.
She did a backtrack. Yeah, okay, no, I work out.
You can bring them on out. You just go on in the jury box. Take a seat, please.
All right, so jurors. Our jurors are present in the county court.
Thank you, Deputy Gordon. Everyone else can be seated. So we need to break for the evening. It's 6, and in order for you to get a shuttle, et cetera, we need to stop now. You haven't been deliberating for all that long, so I don't want you to fret. Gosh, we're not done. There's not a specific done time in something like this. And Deputy Gordon relayed to me that at one point you felt like you were getting close, but this isn't meant to ever be a pressured situation. So I appreciate your willingness to come back tomorrow. Tomorrow is even more so than today or yesterday, a scenario where you're in charge of the time. So we will start only when you're all back here. Is there a particular time you want to reconvene? Mr. Dent needs to be on time. So clearly 9 doesn't work. Maybe it needs to be 9:15. No, but what time? Because everyone ought to know what the expectation is. We're here early and you can get in early if that's your commute, but what works?
Aiming for 9. No, I'll be here.
Right.
Sorry, I'll be here.
And if we miss,
He gonna spend it. I think
he should be
9 o'clock?
Yeah, he's gonna spend the night.
He's gonna spend the night. Yeah. There's a cot in a different space. All right, so 9 o'clock is when I expect you all to be back. You cannot begin your deliberations until resume your deliberations until all 12 of you are back. And our 2 alternates, I'd like you to come back as well, but if either of you could be here within 15, 20 minutes notice, if you've got a call on your magic number, then it's okay for you to be back in general circulation. I don't know your work routine or exactly how far you are from the courthouse, but if getting away from work or home would be an hour to get here, that's too long. But if it is more like 20-ish minutes, then you don't need to come back. So let's start with Mr. Niemeyer. What's your response to that?
So you're saying if I live an hour.
You live an hour away,
15 minutes.
then you should come on down and be here by 9, please.
Sir.
And you can bring work to do because you'll be back in there. And unless we lose a juror, you won't be deliberating. So it is fine to bring however you'd like to spend your morning. It counts as jury service. You'll get paid $5 for that day. But we need you on warm standby. Ms. Herron, same question.
Kind of same situation, I live probably 30-40 minutes away, so.
Then come on down, but bring something to do while you and Mr. Niemeyer are in there. The 12 of you will be going right back to where you were, 9 a.m. There may be issues that are swirling in your head. You should think about them. Don't talk about them with anyone else. Don't go home and say, hey, how would you work through this? You may get very wise counsel, but it will be from someone who is not a juror and who didn't see and hear what you saw and heard. So if there are questions that need resolution, it's with the 12 of you in the jury room. And don't go to your friend Google to look anything up either. You did a great job. You were one of the more prolific juries. In 2 days, you have more questions than I usually get in like a week and a half in like a complicated double homicide. So you're inquisitive, you had your itches scratched except for which hand someone is. You'll work through that. So do you have any logistical questions? Mr. Dent's going to lead the way tomorrow morning. We look forward to it. We will see you all 9 a.m. You just report straight back there. You won't get the evidence back until all 12 of you are there. And then Deputy Gordon will bring you the jury charge and the verdict form and all that. And you can resume your activities.
Do we go there or do we go straight there?
You can go straight to the jury room because they can't start until the 12 are there and then you get ejected. So if you want to mingle with your crew, you can do that. I don't even know, that may not be unlocked even when you get here. Yes, ma'am.
Does it matter if there's things written on the board that he can see or we need to erase it?
That's a good question. I don't want you to erase anything if it's product that you're relying on. So don't go in the jury room. Thank you. That's a great point. I was just thinking there's a room with snacks. He wants some free snacks. And so he wants to get in there. They can bring you snacks. Well, I'll tell you this, when the trial is over, when this group has reached a verdict or whatever the outcome is, we don't send them away before you two are reunited. I actually bring all 14 of you back in the jury room, give you letters to prove where you've been in case you need that for a spouse or an employer, and just debrief you a little bit about what happened. And you may have questions like, why didn't this come in? And we can talk about that once the trial's over. So you'll have a brief reunion. You may set up some online like LinkedIn group for this group going forward. Any other logistical questions? All right, you stayed late tonight. I appreciate that. 9 a.m. tomorrow morning.
All around for the jury.
Oh, chicken bits.
Wow.
Yeah, bring 15, one for Gordon.
You guys, how's it go about that?
Okay.
I'll be right here.
Ms. Beza, anything before we wrap for the day?
No, Your Honor.
Okay, if one member of your team at least could be here at 9, that would be great just to check in, but I've got your numbers. Ms. Rios, anything from the defense?
Just that I will not be here. I'm supposed to be in Peachtree City right now. I'm at a conference.
Oh.
So I'm gonna head there. I will be here Thursday and Friday. I'll be back for trial on Monday.
All right,
I hope that
are you
we're good.
hearing anything about, we'll go off the record now, and we'll see everyone at 9 except for you. So let me do this, 1 second.
Put those back. 8 a.m. doctor's appointment.